Good morning and welcome all. It is now 10 a.m. and I would like to formally open specific issue hearing 7 for the Vannin offshore wind farm project. Before introductions, I'll cover off housekeeping. Can everybody in the room hear me? Thank you. And live stream and recording, have they started? Thank you. Can everyone present in the room please set all devices and phones to silent? Okay, toilets are to my right through the double doors, and there are no planned fire drills during this event. So please leave the building by the nearest fire exit and collect in the car park if there is an alarm. On to panel introductions. I'm Ms. Sahai. I have been appointed under Section 27 of the Marine Infrastructure Management Act 2016, or MEMA, to chair the panel of examiners for this application. I confirm that I have made a conflict of interest declaration as part of my appointment. My declaration of interests and that of my panel colleagues were discussed at specific issue hearing 4 and public meeting 2 held on Monday the 11th of May, and then again at specific issue hearing 5 on the 12th of May. Anyone who wishes to do so may review the published recording of any of those events. I'm a chartered member of the Royal Town Planning Institute, or RTPI, which means I'm bound by their code of professional conduct, including the requirement to operate with honesty and integrity and to exercise independent professional judgment. This underpins my commitment to conduct these proceedings in a manner that is independent and procedurally fair to all. I will now hand over to my fellow panel members to introduce themselves. Ms. Fernandez.
Good morning, everybody. My name is Frances Fernandez, and I am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I have made a conflict of interests declaration as part of my appointment, and I am also a Fellow of the Royal Town Planning Institute, which means I am bound by the Code of Professional Conduct.
Good morning. I'm Ms. Pownall. I'm a panel member appointed pursuant to Section 27 of MEMA. I confirm that I have made a conflict of interest declaration as part of my appointment. I'm also a chartered member of the RTPI, which means I'm bound by a professional code of conduct in the same manner as it does to other panel members and frames my conduct for the examination.
Good morning, everybody. My name is Ryn Smith, and I'm a panel member also appointed pursuant to Section 27 of MEMA. I have made a conflict of interest declaration as part of my appointment as well, and am also a chartered member of the Royal Town Planning Institute, and am bound by its Code of Professional Conduct in the same manner as it applies to the other panel members, and it too frames my conduct in this examination.
Thank you. Also present are members of the Cabinet Office case team, notably Mr. Tom Randall, who provides procedural support throughout the examination process. Audiovisual service is provided by Energy Media Limited. Just a few words about how I intend to run the hearing today. Today's hearing is being undertaken in a hybrid way, which means that some of you are present with us at the venue and some of you are joining us virtually through Microsoft Teams. Some of you have chosen to watch the live stream. Additionally, a recording of today's meeting will be made available on the MEMA website as soon as practicable after the meeting has finished. With this in mind, please ensure that you speak clearly into a microphone, stating your name and the organisation that you're representing, if relevant, each time before you speak. If you're not at a table with a microphone, there are roving microphones, so please wait for one of these to be brought to you before you speak. Just a few words about personal information. When speaking, do think carefully about your personal information. If you feel a need to refer to something of a personal or confidential nature, please remember that anything you do say will be included in the published recording. The Cabinet Office is administering the consenting process for applications made under MEMA, and in that regard, it will process personal data in accordance with Data Protection Act 2018 and GDPR and LED Implementing Regulations 2018. Further information relating to data protection can be found in the Cabinet Office's privacy notice. You can find a link to this notice in the Regulation 32 letter published on the 6th of February, but if you do have any questions, please speak to Mr. Randall. Just a few words about the statutory framework of the hearing. Under Section 31 of MEMA and Regulation 31 and 34 of the Marine Infrastructure Consenting Process Regulations 2024, the examining body can hold specific issue hearings if we think it's necessary to ensure that that an issue is properly examined and that principal stakeholders have an adequate opportunity to state their case. The examination under MEMA is an inquisitorial process, and it is for the examining body to lead the questioning in order to test the evidence before us. For the purpose of this hearing, I will not allow cross-questioning between parties. If parties consider that further points need to be explored, they should indicate this to the examining body, and we will decide whether those matters should be pursued. While we will pursue some of your questions at this hearing today, some might be explored later through written responses from the applicant. Today's hearing is specific issue hearing 7 on the draft marine infrastructure consent, and the examining body notified parties of its intention to hold SI 87 in its Regulation 31 letter issued on the 24th of April 2026. The agenda for SI 87 was issued on Friday, the 1st of May 2026. Just a quick overview of the agenda. In session 1, I'd like to cover strategic and cross-cutting matters. Here, my focus really is agenda item 5, so I will make sure that has enough time. Agenda item 5 flows from conversations that we've had from representations at public meeting 2. It is likely that agenda item 4 we will put to written questions just to make sure that agenda item 5 and 3 get its full hearing in session 1. In session 2, we're focusing on land and rights, and it'll be important to give each of the 3 agenda items adequate time. In session 3, after lunch, we're focusing on the draft marine infrastructure consent. Again, here I do intend to cover everything. However, for agenda item 12B, what we'd said in the detailed agenda is that the outline management plans will be considered in detail at specific issue hearings 4, 5, and 6. And so this agenda item will focus on any strategic matters that remain untested. So what we will focus on here is control mapping for marine activities under the provisions of MEMA. Hopefully that will give enough, this gives the applicant and DOI enough notice to prepare as much as possible over lunch. Session 4 has agenda items focusing on policy framework. For agenda items 13A and B, it is likely that those matters will get covered under agenda item 5 this morning, but I will most likely do a mop-up question to gather summary statements at that time if it is not fully covered. But again, I do intend to cover all the agenda items under session 4, under policy framework. Okay, introductions from attendees. I will start with the applicant, and then I will state the name of the organizations present today, and if applicant, organizations, and other attendees, then just go ahead and introduce themselves. We'll go, so if I hand over to Ms. Sterling.
Thank you and good morning. My name is Amy Sterling. I'm a partner at Pinsent Masons and I'll be representing the applicant today. I'm joined by my colleague, Mr. Toby Yates, who's an associate at Pinsent Masons, who will also represent the applicant today. I do expect that it will just be Mr. Yates and myself who will be speaking.
Thank you, Ms. Sterling. And then if we can get introductions from Government Department DEFA, please.
Good morning. It's Ken Milne representing DEFA.
Thank you, Mr. Milne. And then DOI, Department of Infrastructure.
Good morning. You've got Robert Garden on behalf of the Department of Infrastructure, a partner and solicitor at CMS. And in the room with you today, you've got Emma Rowan and Ian Brooks as well. Thank you.
Thank you, Mr. Garden. And then if we can have introductions from GARF commissioners. If you could wait for a microphone.
Gulf Commissioners, and we have our clerk, Martin Royal.
Are there any particular agenda items, Mr. Smith, that you're intending to speak to?
It's possible we'd like to speak on a variety, but the most specific one would probably be item 13 this afternoon.
Thank you, Mr. Smith. Douglas City Council?
Dana Einan, Director of Environment and Regeneration, and I have two colleagues with me, Chris Pycroft and Ian Jackson. And we're not registered to speak, Madam Chair.
Nobody from Douglas City Council is registered to speak, did you say? Okay, all right. If we could then take introductions from other organisations, could we have introductions from Mr. Gregg, DLA Piper?
Good morning, ma'am. Michael Gregg, Legal Director at DLA Piper. This morning representing Walney Extension Limited, Walney UK Offshore Wind Farms Limited, and Orsted Schroders Greencoat Woods Holdco Limited. I'm only intending to speak on item 11, so my intention had been to log off this morning and come back after lunch for that session.
Mr. Gregg, if you keep in touch with Mr. Randall, just in case we're running late or early, so you don't miss your agenda item.
Yes, of course. Thank you, ma'am.
Thank you, Mr. Gregg. If we can move on to introductions from Miss Ward, if you could tell us who you're representing, please. No. Okay, I don't believe she's present. Any representations from BAE Systems? Ms.
Yes,
Grange,
good morning,
sorry.
ma'am. Hi. Good morning, everyone. My name is Samantha Grange. I'm a legal director and solicitor at Eversheds Sutherland, and I'll be representing BAE Systems operations this morning, or today, during today's hearing session. I think our primary agenda item that we'd like to speak to is item 10, regarding the requirements in the marine infrastructure consent. And so, similar to Mr. Craig, I think we may log off initially, but then look to rejoin the hearing later on this afternoon.
That's fine, Ms. Grange, and if you just keep in touch with Mr. Randall to make sure that we're running on time. Okay.
There's also Mr. Nathan Fern, apologies, ma'am, on the online. He'll be representing BAE Systems Marine.
And again, is it the same agenda item? So are you both going away for this morning and coming back in after lunch?
I'm not entirely sure what Mr. Fern's plans are in terms of logging off and rejoining, but I believe that we will, our common interest is item 10 on the agenda.
Okay, that's fine.
Yeah.
Mr. Fern, would you like to just introduce yourself so we know that your sound and picture is working?
Hi there. Apologies, ma'am. I'm just having a bit of a technical difficulty with my laptop, but yeah, I'll be looking to agenda item 10, and like Miss Grange, probably wanting to log off this morning and logging back on this afternoon.
That's fine, Mr. Fern. Thank you.
Okay.
And then Anthony McNamee. Not here. Okay. Flotation energy. I don't believe they're here. Now on to principal stakeholders. Thank you. Apologies. Before I go there, do we have any representation from Manx Utilities Authorities?
Yeah, morning, ma'am. Stephen McGee, Interconnector Manager on behalf of Manx Utilities. In the room with me today is Carl Capmanara, Estates and Whaley's Manager, and I'll be answering the questions on behalf of Manx Utilities today.
Apologies, I did not catch the name of your colleague. Could you just repeat that, please?
Carl Cacken.
Thank you very much. Okay. Okay. So moving on to principal stakeholders or persons who have registered to speak. I've got Mr. Ian Strafford, not present. Alison Strafford, no. Sarah Wales, no. It might be quicker if I just ask you to introduce yourself, but if you do so only if you've registered to speak and indicate which agenda item you're wishing to speak. So can I see a show of hands of persons who are wishing to speak today and who are registered?
Hello, Patricia Newton, and probably on item 13. I don't know, anything else that crops up.
Thank you, Ms. Newton. Anybody else? Okay, I think that is it with introductions. Before I just move on, can I just check if members of press are attending today? No, there's nobody here. Excellent. We'll swiftly move on to start session 1 and on to agenda item 3. It's a very self-explanatory question, but I'll just set out a little bit of, just give you a little bit of introduction. So we spent a considerable amount of time on this at SIH1 and through written questions. And the examining body is not convinced that we have the information that we're looking for through written questions. So it's, or indeed a clear collation of where the information already set to sit within this application document sits. So I think it's important to emphasize what the examining body's concerns are. And the concern stems from what we see as a degree of asymmetry in the assessment. So on one hand, the benefits of the wider whole project are clearly being relied upon. So in particularly the economic and strategic benefits that would be associated with the export of power through the East Irish Sea transmission project, and the decarbonisation benefits that would be realised to the island if the grid connection or the onshore substation were built. But on the other hand, the disbenefits of the associated, associated with the infrastructure outside the order limits is less visible in the assessment itself. So, as I've said in the agenda, in the detailed agenda, if the applicant can just help us with one or two practical examples, one onshore and one offshore. So if you have prepared something, that's fine, but then I can also fill in with an example if you wish.
Amy Sterling, on behalf of the applicant, yes, I don't think an example will be necessary or certainly possible, at least for the island link. The elements of the whole project which sit outside of the proposed development were included within the EIA methodology described in the project description which accompanies the application. However, as set out in the cumulative effects assessment methodology, which is document APP 073, all projects included within the cumulative effects assessment, which include the other elements of the whole project, and specifically I think this question seems to be focusing on the onshore elements within the Isle of Man, were included within the cumulative effects assessment long list. However, that is subject to screening process, and there are some certain elements that projects have to meet before they're screened in for detailed assessment. Specifically, the applicant has to be aware of the spatial extent of the work, so where they are, the temporal, I've just finished my sentence, the temporal extent, so when they would be constructed, and also have sufficient data to carry out a meaningful assessment. So for the onshore elements of the island connection of part of the whole project, there is no information on the spatial extent, the temporal extent, or indeed any data in which to carry out an environmental impact assessment. Therefore, there are no examples within the EIA of where the onshore elements of the island connection has been assessed within the EIA.
So, Ms. Sterling, that is very similar, almost verbatim to what you said when I asked this question at SIH1, and is very similar to what you've said in response to written questions. But I think the reason we're asking for an example is because we want to understand that the disbenefits have been taken into account in your ES assessment. So it's not necessarily the cumulative. So let me just take the onshore elements. Components such as the tech or the Douglas area onshore substation, have they actually been assessed, given that these elements remain outside the order limits in the ES, in taking into account the disbenefits? So, for example, within the ES, are the likely construction effects of those works actually assessed? And how have you taken into account uncertainties like location, routing, and construction methodology?
Amy Sterling on behalf of the applicant. Just to be clear, there is no Douglas option anymore because that was at Port Skillion. The scoping report, which is also forms part of this application, did consider the Douglas option at scoping and identified likely significant effects of the onshore cable connection and then also an onshore substation connection at 2 potential locations at Douglas. However, as we moved towards the point of application, it became clear that more work was required in consultation with Manx Utilities and the Isle of Man government to identify a location. There is no information on which to carry out an environmental impact assessment of the onshore works, so they haven't been considered within the EIA. So there is no information on the likely significant effects of those onshore works in the EIA. I think it is important that we don't seek to place much reliance on the island connection within the planning support statement. The primary case for the development is to the economic benefit from the generation of power within the Isle of Man for transmission to the UK. And the EIST is subject to a different regime and has been considered differently to the onshore, which are the current subject of this discussion.
So that's interesting. Okay, so you said that hasn't been considered in the EIA. That was not my understanding, but it's helpful for it to be clarified. And I think that leads to a few it leads to a different line of inquiry once you've said that. But let's move on to the offshore elements, which is the EIST. You're saying that the disbenefits of the East Irish Sea transmission is being considered in a different regime, but the benefits that come from the export of electricity through the EIST to the UK is being considered within this application. So I'm struggling to understand how. Do you see how this feels a bit asymmetrical?
Amy Sterling on behalf of the applicant. I understand entirely the point that you're making, that we can't place reliance on the benefits without also discussing the disbenefits. My point is the approach taken for the EIST, where we have more information on location and design than we do for the onshore elements, is therefore different. So for the EIST, we do have a project design envelope that has been subject to scoping within the Planning Act process. The scoping report and scoping opinion has been submitted into this examination, so you're aware of the likely significant effects of that project. But it was also included within the cumulative effects assessment within each EIA topic chapter where it was relevant. However, that is again also subject to screening criteria, and there needs to be a spatial overlap for the cumulative effects assessment. And Dr. Carlin can get into more detail, but generally that's one tidal cycle. We're getting technical as to what the EIA actually considers, but the EIA did screen in the EIST to consider whether that was a relative cumulative project for each relevant topic. That's not the same for the onshore elements within the Isle of Man, which were screened out on the basis of a lack of information and a lack of data confidence. So in summary, the EIST, which we are placing reliance on for the benefits of the scheme, the information on the disbenefits is before the examining body because you are aware of the likely significant effects as set out in the scoping report and scoping opinion, which are before you, but it has also been considered within the cumulative effects assessment within the proposed development EIA.
So the disbenefits of the EIST has been considered topic by topic, but only in terms of the cumulative So just for an example, the effects on benthic ecology of building the route from the array to the UK has been taken into account in the effects or the adverse effects on benthic ecology in total?
Amy Sterling, on behalf of the applicant, yes, that's correct. Where there is a spatial overlap, where the same receptor could be affected by the proposed development works and also the EIST works in UK waters. Dr. Carolan might be able to provide, probably more helpful to provide specific examples in writing. But yes, the EIST has been included as a cumulative project in each of the topic chapters where it's relevant to do so. And that approach is, pretty standard and well precedented in offshore wind projects where the transmission assets proceed separately from the generation assets. They are assessed via cumulative effects assessment.
There's a slight difference, though, between the precedents that you just placed before us, because the EIST is outside Manx territorial waters. So when you say that the effects have been assessed to a particular receptor, are you talking about receptors outside of Manx territorial waters as well?
Amy Sterling, on behalf of the applicant, yes, it's not the location of the receptor that's relevant, it's the location of the works and the cumulative effects assessment. I would also say it's not different. This approach has been taken on many projects I and others have worked on, where the array, for example, is in Scotland and the transmission assets are in England through to an English point of connection, which are entirely separate sort of legal and planning processes.
Okay, I'm going to hand over to my colleagues who have a few questions. So if we can just continue this line of questioning for some of the offshore matters, just because we're on it, and then Ms. Fernandez, if I hand over to you for some of the onshore matters, then that.
I just wanted to ask about what you're explaining within the context of the Mooir offshore wind farm and the concept of assessing the scheme and other infrastructure elements that are associated but not part of the EIA. Can you hear me? Sorry. And your perspective on that example within the context of Mooir Vannin?
Amy Sterling, on behalf of the applicant, yes, we have provided a response and specifically addressed this in response to written question 1153. We are aware of the decision. I think it's important to note a couple of things. Firstly, there was no blanket decision by the court that every application had to proceed alongside its grid connection and that every application had to assess in full as part of its EIA its grid connection. In that case, however, the reporter did find that you can't have regard to the benefits without actually having regard to the disbenefits. It's our position that this application is distinguishable from that decision because you do have information on the EIST before you, which was entirely absent in the Mooir decision. The Mooir decision had no information on a grid connection at all and no attempt at assessment. In this application, you are aware of the EIST. We've got a Section 35 direction from the Secretary of State. It will proceed as an NSEP. We have scoped it. We have scoping report, scoping opinion, all of which is before you, and we have carried out a cumulative effects assessment. The approach we have taken is entirely consistent with many consented offshore wind farms which have been consented and not been subject to judicial review. I'm entirely confident in our position on that.
I understand. Thank you for explaining. But just to be clear, so you're relying on benefits of transmitting their power to the UK, but those are not assessed as part of the application?
Amy Sterling, on behalf of the applicant, they are assessed as part of the application because the benefit of the generation, which is what we rely upon, wouldn't happen without the transmission.
I understand the concept you're saying, but the physical, which is what I think my colleague was driving home at, so the onshore substation and all the associated activities. So you're relying on the benefits of the transmission without any assessment or addressing any of the infrastructure that's not part of your application. Am I making sense?
Amy Sterling, on behalf of the applicant, you're making sense, but I disagree. We have provided information on the environmental assessment associated with the EIST. We've provided a scoping report, we've provided a scoping opinion, and we've included it within the cumulative effects assessment.
Ms. Sterling, I think the reason you've got us a little bit confused here is because you're saying that the way that you have... So first of all, you're saying that the onshore components of the whole project outside of the order limits, such as the substation and in the Alaman, the onshore components are not assessed in the EIS. Yes? So you've made that clear. And then the second point, which is the EIST, which is the East Irish Sea Transmission Project, you're saying you have considered it because it's a part of your cumulative assessment.
Yeah.
Amy Sterling on behalf of the applicant. Yes, I think it's important to understand the reason of the difference. We have control of the EIST. We are developing it. We're promoting it. We have the information, the spatial extent, the temporal extent, and the data confidence within which to provide an assessment. We don't have control of the onshore elements within the Isle of Man. We don't know where they are. We don't know when they'll be brought forward, and we don't have the data to support an assessment.
Understood. That's understood. And I think that there's, when we come to agenda item 5, I will kind of, interrogate that a little bit more, that if you're not taking into account the disbenefits that will occur, then whatever you're relying on in terms of decarbonisation for the island, which admittedly you're not relying on to a great extent in terms of the benefits of that, then that should be discounted as well. But let's park that for 1 second. Just in terms of the EIST, I suppose my question to you is that do you consider that the adverse effects of the considering adverse effects of the EIST in the cumulative effects assessment is the same as is the same as actually considering it as part of the project? Would the adverse effects have the same weighting in terms of what you do to mitigate, for instance, some of those effects? Would it have the same weighting? Is it being tested in the same way as given the reliance that we are placing on the benefits that's going to be achieved through that part of the whole project?
Amy Sterling on behalf of the applicant. Yes, it is included within the cumulative assessment, but you also have the scoping report and scoping opinion, which identify the likely significant effects of the entirety of the EIST, which sit alongside the cumulative effects assessment.
Okay.
I would question whether or not you need to understand the disbenefits to the exact same extent. That's not what the decision said. It said you had to give due consideration to the disbenefits. And my submission to you is that you have sufficient information before you on the EIST that you could be sufficiently aware of the potential likely significant effects and therefore disbenefits to place reliance on the benefits of the generation within Isle of Man territorial waters.
So if we asked you to trace, almost, show us systematically how the effects that are identified in the scoping report trace back to the ES, to your ES, you'd be able to do that chapter by chapter.
Amy Sterling on behalf of the applicant, as I mentioned, they're two separate things that sit alongside each other. The scoping report for the EIST and the scoping opinion consider the entirety of the offshore export cable to the UK. Okay. They consider the landfall, they consider the onshore cable, the onshore substation, and then the connection to the national grid.
Okay.
The cumulative effects assessment for the proposed development only considers those parts of the offshore export cable which are capable of interacting cumulatively from an environmental perspective with the proposed development. To put it more simply, the piling of the array won't have any cumulative effect with the construction of an onshore substation near Penwortham. So there is no cumulative effect there to report in the EIA, but you are aware of the likely significant effects of the construction of that onshore substation in Penwortham because we've provided you with a scoping report and the scoping opinion.
You're saying that it's not going to be considered in the cumulative effects, but without that grid connection, you're not realising the benefits that you're relying on for the Isle of Man, the economic benefit.
Amy Sterling, on behalf of the applicant, Madam, I feel that you're conflating the two things. There is no cumulative EIA effect from the piling of an offshore array and the construction of an onshore substation in England. There is no common receptor pathway. So it would be impossible to carry out a cumulative effects assessment of that basis. What I'm saying to you is that you have the information before you to make an informed decision on the disbenefits of the EIST, because alongside that cumulative effects assessment, you have the scoping report and the scoping opinion.
No, but my question is that without the grid connection on the other side, in the UK, you will not realise the benefit that you're asking the Isle of Man government to count on. Are we clear on that?
Amy Sterling on behalf of the applicant, absolutely.
Yeah. So that connection, the grid connection on the other side, which includes the substation, which is not included in your cumulative effects assessment, is indeed therefore not counted on in your EIS on this side. So the disbenefits of that have not been accounted for in any way.
Amy Sterling on behalf of the applicant. Madam, I think you're conflating EIA and planning policy. That's not... just because we're relying on the EIST doesn't mean there's a cumulative environmental effect.
No, but there is an environmental disbenefit.
From what Amy Sterling on behalf of the applicant, can you provide me an example, please, of where you think our cumulative effects assessment could have or should have considered a cumulative effect with the EIST that it hasn't already? From an EIA perspective, how much more could we have considered the EIST? How could the offshore array interact with onshore works in England, for example?
The reason you are... so it seems like you're using the word cumulative effects to scope out a substation. What I am saying is that the disbenefit of the onshore substation needs to be taken into account because you're counting on that to deliver a benefit. Do you see what I'm saying?
On behalf of the applicant, I understand you fully, and I'm telling you that information is before you in the scoping report and scoping opinion for the EIST. You are aware of the likely significant effects associated with the EIST, and they can therefore, before you in your decision making, you are aware of the disbenefits to the extent that you equate disbenefits with likely significant effects in EIA terms.
Okay, so I think we, both of us, so you have kind of repeated, I think what we're coming back to the same point, and I don't think that what you have given me this morning necessarily gives me any further clarity, except for the onshore part where you've clarified for me that that's actually not in the EIA. From the EIST perspective, I am not clear. I'm not any further convinced that the disbenefits have been fully taken into account in terms of the benefits. So I think rather than you repeating what you've already told me a few times, I think let's just park that there for 1 second. But I'm just going to look around and see if my colleagues have anything further on this. Yes.
I just wanted to clarify. One point that you raised, and I may have misinterpreted it. So the reason you didn't assess the onshore element as part of the EIA, is what you're saying, was the offshore connection to the offshore.
Sterling on behalf of the applicants, onshore elements in which jurisdiction?
Oh, sorry. I'm so sorry. In the Isle of Man. Make that clear. Was one because they're not cumulative with the impacts. I'm shaking your head, but just to clarify, you're talking about the cumulative assessment with the link to the UK. That's what you were talking about, isn't it?
Amy Sterling on behalf of the applicant. We didn't assess the onshore elements within the Isle of Man because there's no information on where they are, when they are.
That's what I wanted to get to.
There's no data. We haven't assessed the onshore elements within the Isle of Man, within the UK, within the cumulative effects assessment, because there's no pathway for a cumulative
I understand.
effect.
So I just wanted to come back to the point that you had made. I think you've summarised the point that you'd made and the point that I was referring to. So when I meant the onshore elements, I don't mean Grudel Bay. I mean the elements that are outside the application. And you said that you haven't assessed them because you have no control. Those are the words you used. You have no control over those elements. I think that's because they're Manx utilities.
Amy Sterling on behalf of the applicant, as I understand it, the specific nature of those works and who will promote those works is still the subject of ongoing discussion between the applicant and Manx Utilities. I don't think there's any final decision that it will be Manx Utilities.
I understand. Okay. I was just getting to why they weren't included. I know they're not the subject of the application, but why they weren't included. I just wanted to clarify that. Thank you.
Okay. So, Ms. Fernandez, do you have
I just want to look back a little bit at some of the history in relation to the onshore part of the scheme, and I know that it's changed and refined over time. So initially there was a proposal potentially for an onshore substation in the location or near to the existing substation at Middle River, and that's not secured, of course, so this is not part of this application, and that discussions were going on with Manx Utilities. But I recall from the application documentation that there was discussion about the excessive length of the cable corridor from Growdell Bay, and maybe I'm misremembering, so if I am, then it would be helpful to set that right. And that is what led to, from my recollection, the introduction of Port Skillion being quite a short hop from landfall to that Middle River location because of the excessive length of the onshore cable corridor from Groudle Bay. So I just would quite like you, and I know we touched on this last time round, just explain how that has or hasn't fed into any of the onshore thinking, because it seemed to me that there were identified disbenefits of a Groudle Bay location related to that excessive length, and I've not heard anything during our examination so far from Manx Utilities to indicate that the onshore connection will be anywhere different to somewhere in the proximity of Middle River location.
Dr. Kieran on behalf of the applicant. At project inception, so whenever we ramped up development consent activities in early 22, the concept of the project at that time was basically was an offshore wind farm with export of all generation capacity to the UK. It was in late 22, early 23 that we started to develop the concept of the island link. And that was written into the scoping report. That was really the first publication that was basically Ørsted's attempt to start the communication with Manx Utilities and Isle of Man government on the island link. So we scoped those elements in. At that time we thought we had much more control. We thought, taking that forward, we would have control over the onshore works. In discussions then with Isle of Man government and Manx Utilities, that has become an evolving feast. Yeah. In the beginning, when we spoke to Manx Utilities, our understanding was that grid connection would be at Middle River. We subsequently put in a grid feasibility request to them at Lord Street, and that was to get the ball rolling, because it was just a high level. It was an assumption that it would be Middle River. So what they requested us to do was to put the grid feasibility request in for 40 megawatts at Lord Street. If we could get then connection at Lord Street, then for 40 megawatts, and that was feasible, then we could seek to grow that from 40 megawatts up, because there was still at this stage, it wasn't really determined what the total megawatt capacity of that connection would be. So we put in the 40 megawatt grid feasibility request. At that time, we thought then we would be going to Lord Street and Middle River. In discussions, as discussions then evolved with Manx Utilities, there was we were trying to seek alignment on the work that they were doing with the Manx 2 interconnector, because there was some disquiet about us having the same landfall site as the Manx 1 interconnector at Port Skillion. So then we looked then at Groudle Bay. It was a greater length round, but there was never any formal decision in the inclusion of that additional landfall site that the grid connection would be to Middle River. It was always most likely, but there was always alternative grid connection options that would have been possible. So to make landfall at Groudle was a feasible alternative that we had in discussion with Manx Utilities. So that's really the evolution of that, and it continues to evolve.
Thank you, Ms. Fernandez. Okay, so I think, I don't think we've moved much further forward, but it's important to just say one thing to just close this discussion out, because I think we got slightly stuck in cumulative effects and the actual assessment of disbenefits as a whole versus the benefits. So I'm just going to hand over to Mr. Smith to make a final point, and then we'll move on.
Thank you very much, Mr. High. What I'm going to ask you to do now, Ms. Sterling, is just to step back from the cumulative effects position, where I think the points that have been made are ones that we are taking away, will mull over, but are understood to the extent that they have been made, so they do not need to be repeated. However, there is a higher order issue which rests in the degree to which security can be provided in an MIC, and it consists of these two elements. How is benefit identified and thereafter taken into account for decision-making purposes? Firstly, in relation to a UK connection, in circumstances where the EIST isn't yet consented, notwithstanding that you are the proponent for it, and we are fully alive to, and a number of us have sat on examinations that have dealt with offshore arrays without connections, so you don't need to go back into detail there, but it's the point about how benefit is identified and taken into account for the purposes of the decision. And then secondly, looking at the Isle of Man connection. And there, it's the same question, how benefit is identified and taken into account in respect of that, recognising that there is a further step back, because not only is it a separate project and not yet consented, it is, in your characterisation and in our view, clear that it is not yet formalised and there is no MIC commitment at all to its delivery. But of course there is a proposition that's been put to us by a number of the stakeholders in this process that it needs to form a substantial component of evaluation of benefit within and for the Isle of Man and its population. So we're trying to make sure that we don't go too much further without trying to be as clear as we can on those 2 points.
So, thank you, Mr. Smith. Ms. Sterling, just before you respond, that is a big component of Agenda Item 5. So, do provide a brief response, but I want to take Agenda Item 5 in a logical order.
Yeah, and that's noted. But I think, given where we tangled ourselves, this will help us untangle. And if it just sets out preparatory frameworks that we can then take forward in Agenda Item 5, I'll be content. But I think we need to be able to sort of pick this apart to a point where we understand where we can then make progress, if we can.
Amy Sterling on behalf of the applicant. I think it's important to note that Isle of Man government policy in support of an offshore wind farm in Isle of Man territorial waters is for an economic benefit to the Isle of Man, not for the transmission of electricity to the Isle of Man. So the primary planning case for the array is the economic benefit that would be generated to the Isle of Man from rent and taxation. It is that we rely upon for the need case, as it were, for the generation assets. The generation assets are reliant on the EIST for their delivery. We have confidence in the EIST being delivered. Certainly no obvious reason why it won't. And Mr. Yates, is going to lead Section 5. I won't steal his thunder, as it were. He's got much to say on that. However, there is less information and less certainty on the island connection. That is, admitted. It would, of course, be open to the examining body to consider that less weight, or indeed little or no weight, should be placed on the island connection for the purposes of determining this application. Indeed, of course, it would be open to the examining body to recommend that consent for works number 3, 5 and 6 was withheld because the need case wasn't met for the island connection. It's our submission that nevertheless the need case for works number 1, 2 and 4, which are the generation assets and the ability to transmit to the UK, would still be met, because the needs case for the proposed development really rests with the array and the economic benefit to the Isle of Man.
Thank you, Ms. Sterling. I think agenda item 3 was very much around the EIS. So, I was just trying to understand in that. So that's helpful. It gives us a wedge into agenda item 5, which I will come on to now. But just perhaps to put a point as we close agenda item 3, that I don't think I still have clarity in terms of the benefits, counting the benefits of the whole project, and in doing so, whether I have been able to take account of all the disbenefits of the whole project, admittedly not the onshore components on the Isle of Man, which you've already, right at the start, scoped out, sort of. Yeah.
Amy Stilling on behalf of the applicant. That it is understood.
Yeah.
I think there's probably more we could do in our planning support statement to assist with that balancing exercise. And this is, a general wholesale update to the planning support statement. It's been discussed many times this week. I think it would be beneficial. We are in, an unusual situation in the Isle of Man. I'm confident in the position that we have. It feels like we've got some sort of, and that it's well precedented. It feels like we've got a bit of an explanation exercise to do. So we can take that away, reflect on the comments that have been made, and seek to put some more information before you, or pull the information before you that's together and present it in a different way that can give you confidence, Madam.
I'm not entirely convinced that the planning support statement is the place to do that, but leave that with me, and we'll think it through, and we'll see how best to turn this into an action. Okay, moving on to agenda item 5 is about the need case for the development. And I'm going to take this in a slightly different order from the published agenda, and we'll just start with agenda item 5D. And the reason for this is that the question of the benefit to the Isle of Man has been raised very directly at public meeting 2. And so the examining body has heard the concern that electricity is primarily intended for the UK market, while the environmental and social adverse effects are experienced in the Isle of Man. So speakers have put forward that there's no corresponding environmental benefit to the Isle of Man, and the examining body must consider whether the financial benefit to the Isle of Man is sufficient to justify the environmental and societal impacts within Manx territorial waters. We've also heard a related concern that the project does not represent a local solution because the electricity is primarily intended, well, is only intended for the UK market. So it will not contribute to the island's sustainable energy targets. So what we want to test first is that what the actual benefit to the island is. Now, the applicant's position is that the primary aim of the proposed development has always been to support Isle of Man government policy for economic growth, for export of power to the UK, and the applicant has also referred to an operational lifetime financial benefit of around 2 billion over 35 years. So I'm just going to start with questions to the applicant and DOI and around the reliability of the 2 billion figure. So the examining body needs to understand how much weight we can place on that figure, or indeed any figure. So we understand commercial sensitivity, but if we are being asked to rely on an economic benefit, which is of an amount of £2 billion, we need to understand how we can give that any weight if the assumptions that underpin that figure cannot be tested.
Amy Sterling, on behalf of the applicant, I would, if I may, Madam, challenge the starting point that you do need to analyse the economic figure and the 2 billion. The Isle of Man government policy makes clear that it considers there's sufficient economic benefit to deliver an offshore wind farm in Isle of Man territorial waters. What it doesn't say is we support an offshore wind farm in Isle of Man territorial waters if it contributes at least 2 billion to the economy. It doesn't say that. It says there will be an economic benefit to the Isle of Man. So I would suggest that the figure of 2 billion isn't a relevant planning matter. Nevertheless, it is notable that the Isle of Man Government Treasury Department has submitted a representation into this examination to confirm that based on its calculations, 2 billion is a realistic figure. So you have both the applicant and independently the Isle of Man Government Treasury explaining that 2 billion, based on certain costs and assumptions, is a realistic figure as to the economic benefit that this proposed development could generate for the Isle of Man in pursuance of government policy.
So what you're saying is that the figure actually doesn't matter. So if the figure was £1,000, it almost is irrelevant because it is already established that there will be economic benefit if you build an offshore wind farm and export the energy to the UK.
Amy Sterling on behalf of the applicant. My suggestion, yes, is that the government policy has dictated. It's for the government to set its policy. The government has set a policy that it considers there's a financial benefit to the Isle of Man, which justifies having an offshore wind project within Isle of Man territorial waters.
Okay, so can I just get some from DOI, if I could get a response on this matter?
Yeah, good morning, Mr. Garden, on behalf of the Department of Infrastructure. I think taking a step back in relation to what the policy is, since 2014, the Isle of Man has had a policy approved by the Tynwald to deliver offshore wind, and that is, I'll just read part of it, but it's progressing plans to develop up to a maximum of 2 gigawatts from offshore wind for power to export to the UK. So that was the original policy driver, and that's what Tynwald approved back in April 2014. In terms of the pure economic benefits, that's a matter for the Treasury Department, and I don't believe you have representatives here today. No. But we do note that they have put into the examination a document PCR 110, the representation, and that they have confirmed that £2 billion figure. As far as the department is aware, and again, it's a different governmental department, it's the Treasury, not the Department of Infrastructure, but there is a taxation regime that will be put in place to address those matters and secure those benefits.
So, Mr. Garden, then it would be fair to say that there is in fact no threshold as such, that the applicant, or indeed anybody, as long as they are delivering an offshore wind farm up to a maximum of 2 gigawatts, would not need to demonstrate to the examining body, it's not before the examining body, that it is delivering an economic benefit of a certain amount, and how that economic benefit is being realized. There's no threshold in that regard at all.
I think so Robert Garden on behalf of the Department of Infrastructure, there's certainly no policy basis for that under MEMA or through the policy statements that have been made or approved by Tynwald. The reference in there is to the capacity limit and to the export of power to the UK. I don't think there is any threshold or figure that you could point to in policy terms to deliver that. So I think fundamentally it is a matter to be, and I know we're coming on to this later, but to be weighed in the planning balance.
Okay. Notwithstanding the fact that this is established in policy and the actual figure itself is not a policy matter, or indeed something to be tested here, and we'll just come to that point in a minute. The principal stakeholders and members of the public are concerned that the financial benefit to the government is actually being treated as a reason to accept impacts that would otherwise not be acceptable. So this is, I'll come to the applicant first on this. So in planning terms, what the examining body is grappling with is how do we conduct a planning balance where the primary benefit to one jurisdiction, which is the Isle of Man, is an economic benefit, and the harm is significant and is primarily in the environment. So this is notwithstanding your assertion that there are decarbonisation benefits, but those benefits are primarily to the UK. So I'm just talking about the benefit and harm to the Isle of Man. The benefit is to the government, which is economic, but the harm is being felt in the environment and potentially by the community. How do we conduct a planning balance?
Amy Sterling on behalf of the applicant. I understand the point. As I said, it is a relatively unusual situation that we're in. I was suggesting considering your planning balance, and again, without reiterating the point, we will update the planning support statement to give this more thought. But what you would be considering is whether this offshore wind farm meets that government policy. And in meeting that government policy, does meeting the government policy, noting there are no other existing or proposed wind farms to meet that policy, does that outweigh the harms which would affect the Isle of Man? I don't think that there's a way or a mechanism that you could validly weigh up the economic benefit to articulate what that would be and weigh up whether 2 billion is enough for the SLVIA harm. I don't think that would be a valid exercise to carry out, because you have to place your planning balance in policy terms, and as Mr. Garden's quite clearly set out, there is no policy for a certain level of economic benefit, but nevertheless it's recognised by all parties that 2 billion is, a rough approximately.
Ms. Sterling, I don't think I referred to the amount of money here at all. I'm just talking generally about economic benefit to the government versus environmental harm in the Isle of Man. I'm not talking about the 2 billion figure at the moment, although I will return to it in a minute. But I'm just talking about economic benefit to the government. How do you compare economic benefit to the government versus environmental harm, which is being felt by the population of the Isle of Man, when you're saying that the economic benefit on its own is not a matter to be tested by the examining body?
Exactly. I think it's the last point. Amy Sterling on behalf of the applicant, it's the last point that's clear, is that I don't think that you can or should seek to compare an economic benefit. If you don't talk about money, I don't know how you would quantify or consider an economic benefit. I suggest that what needs to be done in the planning balance is consider whether this application meets the planning policy to deliver an offshore wind farm, and to weigh that against the disbenefits associated with it. Not money versus environmental harm. And you're saying that economic benefit doesn't mean money. If it doesn't, then what does it mean?
No, it does mean money, but it's not the quantum. The quantum is not what I'm testing in this particular question. I'm talking about so let's just come to, let me try and put this a different way, that if there is economic benefit which relates to this development itself, then, it is an important distinction to make, that this economic benefit relates to this specific development. So, and I don't know if this is, how can the examining body basically treat generic government revenue as a benefit weighed against harm that is felt by the community or the environment? That is my question. It is essentially government revenue established by policy, notwithstanding that, but the harm that is caused is to the environment and to the community. So, how do we weigh that? It just feels, what we've heard at the public meeting is that feels like a financial inducement rather than a valid planning balance exercise.
Amy Sterling on behalf of the applicant, because we would reject any suggestion of financial inducement. I don't think those are appropriate words to use in an examination. It feels to me, Madam, that we're at risk here of trying to rewrite government policy. Government policy is that there will be an economic benefit to the Isle of Man, and therefore that there should be an offshore wind project within Isle of Man territorial waters. It is that policy that you should weigh up in the planning balance, not seek to decide whether or not the government should have a policy to deliver an offshore wind farm for economic benefit. That would be beyond the remit.
It's critically important to resolve that question. The EXB has absolutely no intent whatsoever to rewrite or suggest the rewriting of any aspect of government policy. What we're trying to clarify is what the policy is and how it takes effect. So I think those matters have to be concretely understood by everybody engaged in this process. Moving on from that, we then have to sit in the place where we will have to resolve a planning balance, and it is I think, as everybody around this table has not acknowledged and characterised it, tricky place, because we are not resolving that balance in a setting where the policy framework, in the explicit way that, say, for example, a UK MPS does, characterises and expands upon national need and explains what that consists of, and is within a statutory framework that then places that as essentially an uncontestable within the deliberations of an examining body. Now, we're not in that place. The closest analogue that we have is probably to something that is proceeding in UK terms under Section 105 of the Planning Act of 2008. And so, bearing in mind that that's where we are, and bearing in mind that we then have to resolve the question of balance, and we also then have to resolve the very deeply connected question of what then might be secured in the marine infrastructure consent and why, we have to anatomise these matters. Anatomising them, I will explain to you, requires us to sometimes look at the terrain from the outside, which means that we have not just to confine ourselves to an understanding of the policy framework as seen from within itself, but we have to look at it in the round in all relevant dimensions. So I think it's really important that you engage with the criticality of that, because that, I'm sure, is passing across the minds of Isle of Man civil servants and decision makers. It's certainly passing very strongly across the minds of community representatives. It's central to our deliberations. It needs to be central to yours.
Amy Sterling on behalf of the applicant. Absolutely, it's of course entirely in the applicant's interest to ensure that the examining body is satisfied on the planning balance or has the relevant information before you, I guess, apologies, I'm a little bit at a loss as to what more I can say in this hearing as to how I suggest the planning balance is carried out in terms of this offshore wind farm delivering the government policy to deliver an offshore wind farm for economic benefit. I don't want to repeat myself for the fourth time. I appreciate you don't want to hear me for the fourth time. So I'm not sure what more I can provide you now.
I think there's a few more questions. I'm going to hand over to Ms. Fernandez, but there's a few other lines. And like I said, it is worth understanding that a lot of points we're raising are points that that are before us, because we're grappling with this question, but also because they have been put to us by principal stakeholders who would like clarity on these matters. And I think it is in your benefit to provide some of this clarity. So I'll hand over to Ms. Fernandez, but we will return to some of those benefits to the island.
Thank you for that. I suppose let's try a different tack, if I may. So when we look across to the MPS suite, and accepting that UK is a very different starting point, but what we have there is the urgent national need for energy and critical national priority. And so in our balance, those are really heavy weights. And then when we look here in this jurisdiction and understand the weighing scales and what's in one side and what's on the other, I think what we are grappling, it's not even trying, we are grappling with is what is that economic weight? Is it an urgent need for economic money for money coming into the Isle of Man? Is it a critical national priority? Or is it a nice to have and we'd like some money generated from this scheme? And then where that leads some of the thinking is 2 gigawatts is a target. Does it all need to come from this one array location? Could be somewhere else. Does it have to be delivered within a certain time frame? Could be over a much longer time frame. So I'd be interested to understand any of the applicant's thoughts around that comparison to urgent need, critical national priority, and then is there a way of applying that similar filter to our starting point here and that question of how important is that economic need? Maybe that's just a different way of getting away from the figures, but trying to understand ultimately that balance, which with the MPS is pretty straightforward. Maybe that's the question.
Amy Sterling on behalf of the applicant. Thanks, Madam. Yes, I agree with that analysis. I think it's helpful. One, I would suggest that there is, a strong and substantial policy support because the Isle of Man government policy has spanned since at least 2012 to deliver an offshore wind farm. It is clear, consistent and strong for over a decade. They have set up the Marine Infrastructure Management Act regime. This is the only proposed, as we said, offshore wind farm. We heard from Mr. Garden yesterday. There are no other leasing rounds currently proposed within the Isle of Man territorial waters. As to the urgency of need for the economic benefit, I don't think it's something that I'm able to comment on. I think that's a question properly for the Isle of Man government.
Maybe we could ask DOI or
Mr. Garden. I think that's a really good question and a good one for you to come in on. And I think the point of urgency or how important it is a really good one because this policy, like you said, has been there since 2014. We're in 2026. How important is it for you to meet this policy requirement? For instance, what level of adverse effects are acceptable in order to meet these policy requirements?
Yeah, Mr. Garden, on behalf of the Department for Infrastructure, I think in relation to and seeing where you're going and the issue that you're grappling with, it is worth referring back to, again, the 2014 report, and that's the report on the strategy for offshore energy production that was approved by the TIMWOD in 2014. And in relation to this specific point, what this policy document says is effectively that I will read it because some of the language I think is important for your consideration. But it says there's a significant opportunity for the Isle of Man to lease the seabed for the generation of renewable energy for export to assist the UK. And then it does include some potential quantification around what that significant opportunity is. So it talks about a project with an operational lifetime of 25 to 50 years, and with revenue to the Isle of Man government at that time of £5 million per year. So giving a range of potential impact that the Isle of Man deemed to be significant when it introduced this policy. So I think that's where you are. In terms of the question around the weighing of adverse effects, what this doesn't do is go into to any detail around that weight in terms of adverse effects. And I think, and I know we've got planning balance as an item for later, but that does probably then take you into a weighing exercise and looking at the Isle of Man strategic plan and the MPS and the equivalence of sort of section 105 under the Planning Act for that exercise.
Mr. Garden, can I just press you a little bit more here? What you've given us is you've fleshed out what that policy is, but that is before us and we've understood that. I think the question or the point that Ms. Fernandez was driving at is that how much weight do we give it in terms of things like urgency and importance, and what is reliant on that economic benefit, or indeed can we give it weight on the basis of urgency and and what it brings to the island?
Mr. Garden, on behalf of the Department for Infrastructure, I think I'll have to take that away in terms of the urgency, because the policy doesn't at that stage in 2014 set a specific time frame for achieving that objective. So I would need to take that away.
Yes, I think that would be very helpful. And a policy that was introduced in 2014, we're now in 2026, doesn't feel particularly urgent, would be my observation, but I would be very interested in see what DOIs have to say about that.
Amy Sterling, on behalf of the applicant, if I may just sort of expand that request, and I appreciate your preparing your frustrating questions. I suggested it's also a question that should go to DEFA Planning Policy and also the Cabinet Office. It would of course be extremely helpful for the applicant to have clarity to allow us to frame our planning support statement in a way which is helpful to you.
Can I just briefly, at risk of complicating, but add into that mix a consideration of the island plan? Because the island plan does contain a summarised policy commitment that appears on its face to be relevant. And so an understanding of the relationship and bearing of that plan's provisions on the deliberations of the examining body and indeed the final deliberations of the decision makers would also help.
Ms. Panna?
I appreciate the point made by the applicant that the figure of 2 billion is not a consideration in this process, but you're trying to balance the environmental impacts and disbenefits of the scheme, which is what my colleague's explaining, against the benefits, and there has to be some proportionality to a benefit. So although the figure's not relevant, and I understand what you're saying, there has to be some kind of way of harnessing what the benefit actually is, and I think that's what everyone's grappling with. And I think Mr. Garner mentioned the 5 million, was it 5 million, Mr. Gardner, in the 2014 report?
Yeah, Mr. Garden, on behalf of the Department of Infrastructure. So the 2014 report, and it's just why I wanted to refer to that section, it says a significant opportunity, and it talks around £5 million a year at that point in time. I understand.
So I don't know whether there's, I think the panel need to think about it a little more carefully, but whether there's some written question around, I'm not quite sure what the question even is, but you understand where I'm going with this. It's quite a blunt tool to say it will bring finance. There's an economic benefit. That's a very blunt tool to measure a whole range of environmental impacts against. And I'm just trying to unpick that blunt tool a little bit, maybe with the 2014 report, which, as my colleague has just pointed out, is actually quite old. But I think the panel will take that away and ponder a little bit on it, and perhaps in written questions explore it a little more.
And just to add to that, and Ms. Sterling, we would like a response to that question, because I think it's really valid that we do have to understand proportionately. I think I just want to raise some points, again raised by principal stakeholders, Douglas City Council, that how does this benefit translate into benefit for the people of the island itself? So have you or government departments thought about that? Is that something that needs to come before the examining body? Is that something that needs to be explained to, the residents and businesses on the island who are experiencing the disbenefits, which includes visual intrusion and possible impacts on, their tourism, etc. That how does the economic benefit to the government translate into benefits for the people?
Amy Sterling, on behalf of the applicant, the Isle of Man government is a democratically elected government who represent the people. They're not distinct entities, madam. If it benefits the Isle of Man government, it benefits the Isle of Man, or certainly that's what their policy says that it will do.
I think that's axiomatic, and I mean, with respect, I think what we're trying, we've got a serious issue at issue here, and what we're trying to focus on is, I guess, teasing out the relationships between the government in its representative capacities policy and the benefits. So if we could view that in those terms, that would be very, very helpful.
Amy Sterling, on behalf of the applicant, we can certainly give more thought. Again, would really welcome the Isle of Man government's views on all of these points.
I'm coming to them, yeah. So I think at this point it would be helpful to, sorry, I'm just going to electricity. Yeah, so I think at this point I'm quite ready to, in this area, just mop up a few responses. So how, and again, Mr. Garden, it's absolutely fine to refer to the 2014 plan, but it would be helpful for us to understand how the Isle of Man government thinks this economic benefit reaches the population of the island. And again, just bear in mind that, this is a question, of course, the examining body is concerned with, but it's also the question that's come to us through public meetings in this independent process. So, it is worthy of a response.
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, that is understood, and we will follow up with the Treasury Department to make sure you have that information.
That's reassuring. I do want to invite DEFA at this point if they have anything further to add on anything that they have heard so far.
Ken Milne, representing DEFA. I don't believe so. We've covered the government policy back in 2014 and how it's been consistent ever since then for offshore wind, but I don't think I can comment on anything else at this stage.
Thank you, Mr. Milne. Okay, so I'm just going to carry on. There's a couple more matters that I want to cover off under agenda item D, and then I'll move on to A very quickly. Just in terms of the island connection electricity benefit, I think we've covered this in agenda item 3. And I think we know the answer, but my question was going to be that there's 2 months into examination. Is it still as certain or uncertain about the island connection? Is there any further clarity on what you're going to do, whether that clarity is in connecting to the island or you've absolutely decided not to?
Amy Sterling, on behalf of the applicant, there's certainly no decision not to. That's very much still a subject of discussion with Manx Utilities and the Isle of Man government as to whether or not the Isle of Man government wishes for the island link to come forward.
Okay, so then that just leaves the final point, which I touched on and we parked in agenda item 3, which is that if it is, given the uncertainty and given that it's not in your gift to connect to the island, the benefits, the decarbonisation benefits to the island or the energy supply benefits to the island, therefore, should be completely discounted from planning balance. Can I have a comment on that?
Amy Stilling on behalf of the applicant. We do address this in our planning statement. Our view is that given the opportunity for the Isle of Man government, should they wish to take it, to benefit from renewable energy from the proposed development, that there should still be some positive weight placed upon that opportunity. Ultimately, of course, the examining body may feel differently given the level of uncertainty associated with the island link. I've mentioned in my previous submissions it would be open to the examining body to account little or no weight to the island link, or indeed to recommend that the island link isn't included within the final MIC to be granted. That is entirely open to you, of course, within your recommendation report. We consider that there is some benefit to be ascribed for the reasons I've discussed.
So you're saying that the benefit, whether limited or moderate or whatever we place on it, is on the opportunity to be able to generate electricity supply for the island rather than the actual supply.
Amy Stilling on behalf of the applicant. Yes, I think that's the only way it could be given we don't have a grid connection agreement or indeed any confirmation from the Isle of Man government that they want to take it forward.
Okay. Just on this point, Mr. Garden, can you... do you have any view on what kind of weight can be given to actually energy supply coming to the island?
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, I think our view accords with the applicant in terms of it's the potential that you attach weight to. And I think going back to the discussion that's been had around benefits and disbenefits this morning, one of the suggestions that we have made in relation to the draft MIC is to effectively have a Grampian style requirement in relation to the Isle of Man connection works that form part of the MIC to be linked to future either consenting or delivery where there is certainty around the island link, and think that provides the connection in terms of the assessment, the approach to weighting, and then potential linkage through the draft MIC itself.
Any thoughts on that?
Amy Stilling on behalf of the applicant. Yes, we're aware of the DOI's request. In principle, we don't object to a Grampian style condition for the onshore elements of the Isle of Man linked to the offshore elements of the island connection. We have been liaising with CMS on the particular drafting to make sure that it works in the circumstances that it's either the applicant and or Manx Utilities who brought forward that onshore connection, whether it's under TCPA, whether it's permitted development. There are a couple of sort of unknowns at the moment that we'd have to factor into that drafting, but that work is ongoing between ourselves and the DOI, and we'd hope to give an updated deadline for.
You're actually proposing the drafting at deadline for?
Amy Stilling on behalf of the applicant, if we can agree suitable drafting between us, yes.
Okay, so if you could, if the drafting is not agreed, could you update us on this in the statement of common ground? So if we can note that as an action, that would be good. Okay, I think we can now move on to agenda item 5A. And Mr. Garden, I think we'll need you quite a... I see that there's a comment from the floor.
Jamie Smith, Garth Commissioners, democratically elected representative of the residents. I had a couple of points that I would like the examination body to perhaps clarify for me. Mr. Garden referred to the April 2014 agreement for 2 gigawatts of electricity production. Now, my understanding was that at that date it was 700 kilowatts, and I would be very interested to hear what date and under what form that was increased from 700 to 2 gigawatts. My second question is, and I know it's distasteful to discuss money amongst friends, and we're all friends here, but we are talking about, well, the euphemism I've heard tonight is disbenefits. We're talking about potentially people's house price being devalued and things like that. So in the context of that, the £2 billion, I'd like to know, is that in fact 2 billion divided by 35 years, therefore 57 million per year, and that there's no roll-up? So let's say due to something like a change of UK government policy that the project doesn't make any profit in one particular year, that's 57 million lost that year. And this is not really 2 billion over the whole period. It is 57 million per profitable year over the project. I'd also wonder whether the examination body would like to receive a comment from URSID about their track record as far as capital allowances. I know that the HMRC had to go to the Supreme Court over Walney, and I mean this is a real worry for us. We're trying to view the planning balance, and we clearly are seeing disbenefits for the community, and so therefore I'm asking what assurances do we have about the benefits. And I think I've got a final point, if you don't mind. I think the comment from Ms. Fernandez about the fact that the policy was written in 2014 and now it's 2026 and how urgent that is very apt. Thank you.
Thank you, Mr. Smith. So I think just on your first point, we covered that quite a lot in SIH 5, and there are several hearing actions relating to that. So I would say if you look out for the applicant's responses, as we are eagerly awaiting those responses as well. On the second point, which is the £2 billion figure, I think we've pushed that as far as we can within this hearing setting. I can assure you the examining body has further questions, so that will be explored further through the examination. So I'm not going to press on that anymore. And then...
Capital allowances?
The capital allowances is being covered later in the agenda under funding statement. And the fourth point about the age of the policy document, as you've already picked up, that is a hearing action. We've asked the applicant as well as DOI and other government departments to comment on that. So there's nothing further from your comments. I can assure you they're all live examination matters, but there's nothing further I'm going to press on today.
Thank you for your opportunity to
Thank you, Mr.
discuss.
Smith. Okay, I'm just very aware that we've got about 4 minutes left, and I do want to try and finish this agenda item before we go on our coffee break. So 5A is the EIST dependency, and we've kind of covered that. Mr. Smith brought it up a couple of times already. But I just want to get Mr. Garden back, in the virtual room, and to basically ask that if the EIST is not consented, the applicant is looking for an alternative route to market. And in that regard, DOI, in your response, you have stated that the absence of an EIST consent, the whole project is unlikely to be viable and the need case would be substantially reduced. I just want to ask the applicant that in that regard, how can the examining body attach substantial weight to the need for the proposed development, or the case for the proposed development, let's not use the word need, when the principal export route depends on an unconsented project?
Toby Yates on behalf of the applicant. So I start here just by clarifying that it's open to applicants to choose to progress different applications for different elements of a whole project. So we've got the EIST for the transmission, and then the Mooir Vannin project for the proposed development for the generation. That accords with national policy from the UK. So you've got paragraph 4.11.8 of NPSEN 1.
Sorry, Mr. Yates, if you don't mind, I think we've got a lot of that argument before us. My question is quite simply that how can we attach weight on a scheme that is unconsented at the moment? So unless there's a consent in place before the examination closes, how do we attach it any weight, given DOI has already said that if that project does not get consent, then the case is substantially reduced?
Toby Yates on behalf of the applicant, that's understood. I'm getting there. So the next point I was going to raise is that there's no basis in law or policy that weights attributable to an element of a wider project, in this case the proposed development, should be reduced just because there's other consents for that wider project that are still outstanding. And the paragraph reference I was just referring to is explicit in that regard by allowing different elements of a wider project to be brought on different timeframes by different legal entities and for different commercial and other reasons.
Okay.
There's strong precedent in favour of that. approach. And recent examples that we can point to are the Morgan offshore wind farm generation project, the Five Estuaries offshore wind farm, and then recently and helpfully the Springwell solar farm, all nationally significant projects in the UK. And the Secretary of State in the Springwell solar farm confirms that a planning permission for other elements of a wider development, and I quote now, does not reduce the substantial positive weight afforded to the need argument. Okay. That's paragraph 4.17. And it's helpful as well that in these cases where you've either got a transmission element to come forward similarly to the Mooir Vannin project, or you've got a national grid substation, for example, that's outstanding, all of these consents were granted in favour of the generation asset coming first, which is the situation that we find ourselves in here. And without labouring the point, the decisions I just pointed to are the latest in a long line of planning decisions that follow that suite. So you've got the Tritton Knoll offshore wind farm, Hingley Point C generation, for example. And the point there is that this isn't a new point being considered by a decision maker. It's been considered by the Secretary of State in the UK many times before. And each and every case, the substantial weight for that generation asset was considered enough and could be given in favour of that consent, despite other elements of the consent being subject to different applications.
Different. Okay. Thank you. And sorry for interrupting you, but I think it was altogether very helpful, your representation. So that's those references are good. I think what would be helpful when you provide a summary or potentially as a hearing action is that all those projects that you've just listed, can you just make the comparison which is directly applicable to this case. So it's not just about a transmission asset being separated from the actual application. It's about the reliance on that transmission asset to realize some of that, the benefits that are being generated. It's just worth highlighting that over here, the realization of those benefits is almost entirely reliant on this transmission asset. So that comparison between this project and those projects, and how then that policy and precedence becomes relevant would be very helpful to the examining authority. I will note that as an action because we want that separate from your summary.
Yeah, if I can just briefly assist there from a standpoint of actually having been a member of the examining authority for Tritton Knoll right back at the very beginning of this, when the very first consideration was given to a potential consent in circumstances where a connection to the transmission system had not formed part of the application. And clearly there, in terms of the policy that applied at that point in MPS and EN3 as it was, we turned our mind to the question of whether there were reasonably foreseeable potential connections in circumstances where a specific individual connection had not been brought before us. And in terms then of resolving questions around weight, we felt that it was important, and the Secretary of State, in accepting the recommendation that was made on that point, I think agreed that as long as we were clear within the policy framework that applied at that time that there were reasonable prospects of an alternative form of connection or a range of forms of connection, that weight could be placed upon the overarching generation benefits that an otherwise unconnected array offshore prospectively provided. Think on that, read the recommendation of not just Triton but the others where similar matters have arisen. Think your way into whether the circumstances that were evaluated by examining authorities there amount to the same circumstances as being evaluated by this authority. Is that clear?
It's on behalf of the applicant. Yeah, that's entirely clear, and just we can come back in more detail as requested in our written submissions.
Brilliant,
but
thanks.
Just to take that point and the Chair's point briefly here, we'd suggest that it's entirely comparable because you've got the Morgan offshore wind farm project where you've got separate transmission assets which align very similarly to the transmission assets that we've got for this development. And by principle, the Five Estuaries offshore wind farm, without the new National Grid substation, the generation asset would have nowhere to go. So it's as essential to that development going back into the grid system as it is for the Mooir Vannin project. And just taking Mr. Smith's second point there around in that historic project looking at reasonable alternatives, I think it's important to note here that whilst the delivery of the whole project is contingent on the delivery of the unconsented EIST, there's no obvious reasons why the EIST won't be brought forward or is likely to be refused. And that's in accordance with national policy in the UK. And there's various reasons that strongly support that, including there's a grid agreement between National Grid and the applicant of the EIST. National Grid has a statutory obligation as a regulated business to meet any requests for new power connections. And importantly, the EIST is already subject to a Section 35 direction in the UK, and therefore it's classified as critical national priority infrastructure. And on that basis, and in accordance with the national policy, it's likely that the need case will outweigh the residual effects. And therefore, in line with the precedent we've pointed to, there's no obvious impediment to the EIST coming forward, and it's within that context only that the EIST is relevant for attaching weight to the generation asset.
Okay, thank you, Mr. Yates.
Yeah, can I just say, though, that really is prejudging and predetermining something of which we know nothing about. So whilst hearing your opinion, I think that really is not something that we would put any weight on.
Sterling, on behalf of the applicant, please can we clarify your comment, what Mr. Yates has described as the process set out in the national policy statements for projects which are subject to a Section 35 direction, which is that they benefit for the full weight of national policy, including being classified as critical national priority infrastructure. The other elements that Mr. Yates referred to are simply matters of fact. The applicant does have a grid connection agreement with National Grid at Penwortham, and the applicant and National Grid does have a duty to connect. So I would be grateful if you could please clarify your comment.
Yeah, it was in relation to whether an examining authority in the UK, whatever view they may reach, is what they may reach.
Amy Sterling, on behalf of the applicant.
I don't think we need to keep going backwards and forwards on this.
I think it is important for the record to note that the national policy statement does reflect what Mr. Yates set out, which is that the need for any critical national priority infrastructure is, except in exceptional circumstances, likely to outweigh the residual effects. That is what the policy says.
Mr. Yates, just taking on Ms. Fernandez's point, in responding to that, the hearing action, I think what Ms. Fernandez is saying actually does carry weight. So I would place emphasis more on Secretary of State's decision letters, and not to say that the NPS policies are not relevant, but if you could really pull out where the Secretary of State's decision letters support that approach, where an unconsented scheme has not had an impact on, has not reduced the weight placed on the benefits achieved from a scheme, of a related scheme.
So yes, on behalf of the applicant, yes, we can do that in our written submissions, and would welcome that would be the end of that point. The precedent does support the approach that we're taking. Good. The references to the policy would just be supplementary to that.
Okay, thank you. Okay, just turning to you, Mr. Garden, if you have any comments on this point, do you agree with the applicant, disagree? And the other thing that I would just like your view on is, because we've talked about this with respect to the onshore infrastructure, because of what you have said, that the need case or the case for the development would be substantially reduced without the EIST, do you think that a Grampian-style condition in the draft MIC for the EIS, for any components, well, obviously that's not in the EIST, but any Grampian-style conditions to works related to that would be an approach, would be before the examining body?
Mr. Garden, on behalf of the Department of Infrastructure, I think on the first point, we don't disagree. There is that increasing wealth of precedent in terms of Secretary of State decisions that have been reached, and there is the policy statement, and I do think it is relevant and particularly important given the policy framework here, that the test in EM1 is no obvious reason why a network connection would not be possible. So I think that's the policy framework. In terms of the second element, there is, I think, a difference between the Isle of Man connection, which, by virtue of the legislation that sits beneath it, effectively the marine infrastructure consents part of a grid connection to the transition joint bay, which is in part why we are also seeking that Grampian style condition in relation to the works to the island, to ensure that there is no stranded asset if that is not delivered in the future. And we've touched already on the benefits and the disbenefits and the information in front of this examination. Whereas for the EIST, for the connection into the other regime, there is information in front of you in terms of environmental effects. So I think it is a different set of circumstances in relation to the two potential connections.
Okay, all right. Yes, so it is a different set of circumstances. You're quite right. Okay, we'll leave that there. Coming to point 5b, alternative routes to market. So, applicant, can you tell us anything about the alternative routes to market that you're considering, whether there are any live options, and if you have to go down an alternative route, would that materially affect the economic benefit that you're relying on? And here I do want to come back to the figure, which is the £2 billion figure. Would that materially affect the quantum of the economic benefit that the island can realise?
Amy Stilling, on behalf of the applicant, there are no other alternative routes to market proposed. The EIST is the only route to market.
You've just made reference to that, I think, in your response to first written questions, that you would consider alternative routes to market if the EIST did not have permission, which is why that's led to this question.
Amy Stilling, on behalf of the applicant, I think that was, if that statement was made, I don't have the information before me, a speculative statement. The EIST is the route to market for this offshore wind project.
So if the EIST, despite what Mr. Yates has reassured us of, if it was not to be consented, you potentially then have stranded assets in Manx.
Amy Stilling, on behalf of the applicant, the applicant would never build the generation assets, and there would never be circumstances that there would be stranded assets. They wouldn't incur, £3 billion of construction expenditure building an offshore wind farm if there was nowhere for the power to go.
So would you then include that in the draft MIC? Would you just include something in the draft MIC?
Amy Stilling, on behalf of the applicant, we consider it's not necessary for there to be a Grampian style condition for the EIST for the reasons Mr. Garden has just described.
Yeah. And not for the EIST, for the entire project. It's like that you would not build a project until you have an EIST consent. Well, they've said that that's their only route to market.
Amy Stilling, on behalf of the applicant, we do have a means of connection. We have a grid connection agreement. Just to be absolutely clear, we have a grid connection agreement at Penwortham for the capacity of the offshore wind farm.
But you do have a grid connection, but you don't have consent for that project. And you've just said that if you don't get consent for that project, you would never build more Vannin. So would you then put into the draft MIC basically a condition that you would not build the scheme until you have an EIST condition consent?
Amy Stilling, on behalf of the applicant, we would reject that it was necessary as a planning condition. Again, this has been considered by the Secretary of State on many occasions, including in the Morgan and Swingwell decision that Mr. Yates referenced, that there's no realistic prospect of stranded assets, therefore there's no planning purpose for such a condition.
Mr. Garden, can I get views from you on that? And just, given that you are representing one of the government departments in the Isle of Man, given the strength of feeling from, members of the public and principal stakeholders, and some of the concerns around what happens if, can I just get some comments on the point that the applicant has made that they would never build this project unless EIST had consent? Is there any need for the draft MIC to have a condition relating to that consent?
Mr. Garden, on behalf of the Department for Infrastructure, I would need to take that away and get instruction. I don't think at this stage we have seen that need because we have recognised the approach that the Secretary of State has made in DCO decisions in relation to that point. Okay. But happy to take that away as an action. Okay. That's good. And if I could just mark this as an action for both the applicant and Department of Infrastructure. Okay, I'm just very aware of time. I do want to just finish off one final thing. I don't think it'll take me more than a couple of minutes. Timing and weight, and I think this is actually relevant, so it might take more than a couple of minutes. But when do the benefits realize for this project? When do you realize the benefits for the project? So will they arise at consent? You know, the economic benefits to the Isle of Man, will they arrive at consent or construction, first power, CFD award, EIST consent, EIST build out? At what point do you start realizing these economic benefits?
Amy Stelling on behalf of the applicant. They're linked to the generation. So my working assumption in response to this question is that they're linked to the generation. I'd have to take away specifically when, for example, taxation, rental income, etc. What the specific date of that is. I don't have that information before me.
So I just want to return to the point that Mr. Smith has well made right now, which is how does this £2 billion start coming to the island? And so if you take that away as a hearing action, that's good. And then just related to that, how, again, going back to the point about attaching weight, if there is any uncertainty on the timescales, or if the benefits to the island are being realized only 5 years down the line or 10 years down the line, does that have an effect on the weight that we can attach to that benefit? So, you know, particularly if the weight that you're asking us to take into account relies on future government revenue.
Amy Stelling on behalf of the applicant. I would suggest it's an operational lifetime benefit, but without knowing the specific dates, I would struggle to give you a specific answer. So I think that's something I'd have to take away as well in terms of the dates that the financial benefits, the economic benefits accrue. I don't have that information before me, so I would need to reflect on that.
Okay. Just on that, Mr. Garden, I think it would be really helpful to understand, again, some of this is not relevant to the examining body in its exactness. So, you know, we can't necessarily say, oh, it must happen in 2 years and then we will give it great weight. That's not the important thing. The important thing that is it understood by the parties, and is what the applicant assuring you of, and what is secured through, you know, anything that's before this examining body, is that what's understood by Isle of Man? So I think I do need that response from you as well, that have you understood how this economic benefit is coming to you? When is it coming to you? Are you satisfied with that schedule, so to speak?
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, I think this probably is captured by the discussion that we will have with the Treasury Department, but absolutely taken on board as an action from our side.
Okay. I believe my colleagues have a couple of questions. Ms. Fernandez, Ms. Pownell, did you want to take that? Yeah, okay.
Just a quick one, and not from you, Mr. Garden, but for the applicant, if I may. In relation to the socio-economic benefits set out in the application, is that totally separate and not related to the 2 billion figure? I mean, I'm assuming that is the case, but I just want confirmation.
Amy Stelling on behalf of the applicant, I'm advised yes. Amy Stelling on behalf of the applicant. Apologies, I do know we all want to get to tea and coffee. Just, I think, to reiterate a point that Mr. Garden just made, is that I do think it would be really useful that we recognise, obviously, the Department of Infrastructure is one element of the Isle of Man government, and when we are seeking more information on benefits and policy, that we do seek that information from the Treasury and the Cabinet Office as well in your written questions, because that would be helpful to us.
Okay, that's noted. So if that action can be addressed to Department of Infrastructure, Cabinet Office, Treasury, and the applicant, that'd be great. Okay, good. So we are at 11:49. If we can return at 5 minutes past 12, please. Welcome back, everybody. It's 6 minutes past 12, and we're starting session 2 of specific issue hearing 7. This session is on land and rights. Let's jump straight into 6, agenda item 6. And basically here, based on some of the submissions we've received so far from the applicant, Department of Infrastructure and Manx Utilities Authorities, we have follow-up questions on how we can rely on voluntary negotiations and what happens if voluntary negotiations fail. So once again, just to establish some points of common understanding, the applicant is not seeking compulsory acquisition powers, even though they're allowed to under MEMA. The Manx Utilities Authorities' statutory powers are not presently engaged for the purposes of this MIC application. And the current position appears to be that you will either be successful in voluntary negotiation, or there'll be a future change process introducing compulsory powers or transfer arrangements for the MUA to engage. Is that correct?
Amy Stirling on behalf of the applicant, yes. So primary voluntary negotiations, if those fail, we could seek a future change application to introduce compulsory acquisition powers. Alternatively, we could engage with Manx Utilities to transfer the benefit of the provisions of the Island Link works to Manx Utilities under the relevant provisions of the MIC, and in which case Manx Utilities may at that point take forward a compulsory way leave or a compulsory purchase order, and then the very backstop is the Island Link wouldn't be delivered.
Okay, so at the current time, there is nothing in your draft MIC that allows you to secure the necessary land rights should voluntary negotiations fail.
Amy Stirling on behalf of the applicant, that's correct.
Okay, so that's under 6A. So actually, it would be helpful to get a view from Mr. McGee and Mr. Garden if you have had an input on that.
Steve McGee, Manx Utilities. I'd just like to say we agree with the applicant's summary of the current position, and it generally aligns with our joint statement in our written question to 1.5.2.1.
Yeah, so yeah, that's understood, and that is read. You should take that as read. Mr. Garden?
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, again, taking our statement as read, that's the department's understanding of the current state of play in relation to land rights and the position.
And is there anything different, given that you're working on Grampian-style conditions to be introduced to the draft MIC? Would that be different, or would that have an impact on your position on land and rights?
Amy Stirling on behalf of the applicant. The current scope of the discussions between the DOI and the applicant are related to a Grampian style condition for planning only, because there is no requirement under MEMA or any planning legislation in the Isle of Man that the applicant for planning permission or the beneficiary of a planning permission needs to be the landowner. So there would be no justification for that requirement if it were to relate to land, if I think that's what you're referring to.
Can you just explain that a little bit more? So the Grampian style condition is for planning only. So those components of the project don't need to be built unless whatever the conditions you place in that,
unless there is a consent in place for the onshore elements of the Island Link, or this is the bit where it gets a bit confusing, they're taken forward via permitted development rights or some other mechanism. That's the wording that we're still working through at the moment. It's not related to the acquisition of land rights. Of course, the practical reality is that planning permission, which is effectively what the MIC is for the landfall works, is only one element. If planning permission were to be granted, the applicant wouldn't be able to implement it unless it had the necessary land rights in place.
Right, so it's not, in fact, if anything, the Grampian style condition means that if you had compulsory acquisition in the MIC, it would weaken the case in a way, almost.
Amy Sterling, on behalf of the applicant, I can see that line of thought, but we obviously don't have that.
What did you say, sorry?
I can understand your line of thinking there. I would have to think it through, but it's a hypothetical scenario because we don't have compulsory acquisition powers within the MIC application.
Fine, okay. All right, so just on 6B, reliance on future change processes and transfer to MUA, just help us understand this a little bit more. That realistic to what extent is the proposed development actually dependent upon a future transfer process or a future change application for this? So do you think that that's a likely scenario, that you'd have to go down that route?
Amy Sterling, on behalf of the applicant, it's not the intention, and certainly the land negotiations are progressing well, so that's a later agenda item. It's still the applicant's intention that all voluntary land agreements will be in place in 2026, so this year, well ahead of the start of the construction period. Nevertheless, there are potential routes open to us if, for whatever reason, those voluntary agreements aren't secured, or indeed, of course, a landowner defaults under the relevant option agreements.
Fine. So, and just can you outline for the examining body what MEMA says about reliance on future consents and permissions?
Amy Sterling, on behalf of the applicant. Apologies. Can you clarify? Do you want me to?
So, the fact that you are relying on a future consent should voluntary negotiations fail. So, you're relying on potentially being able to get a change application accepted, or you're relying on a different party being able to transfer the benefit, which of course you'll have a provision to do under the draft MIC, but you're relying on a future negotiation, being able to do a compulsory acquisition through MUA. What does MEMA say about that?
Amy Sterling, on behalf of the applicant, is there a specific provision of MEMA that you are referring to that I could refer to?
No, actually, I'm asking you if there is a specific provision in MEMA which talks about the reliance on future negotiations when it comes to the deliverability or components of this particular scheme being delivered.
Amy Sterling, on behalf of the applicant, not that I'm aware of. I have reviewed MEMA several times in the run-up to this application and enduring. I'm not aware of any specific provision in MEMA that would deal with that at all. Obviously, MEMA grants powers and scope for the application, one of which is the compulsory ability to apply for compulsory acquisition powers, which we haven't taken. I wouldn't envisage, like the DCO regime, it would say, and if you don't apply under here, you can't pursue them elsewhere, or some other sort of scenario. Not aware of anything in MEMA, madam. Amy Sterling, on behalf of the applicant, we can of course check. I've not read the full act just before me.
I know you've talked about, you've compared the situation where compulsory acquisition was not included in a DCO application. However, your reliance on being able to work with another party to do the compulsory acquisition for you, or relying on a change request or a change to the application. Is there an equivalent DCO process where, the acquisition of land and rights was reliant on future legal tools which were not currently before the examining body?
Amy Sterling, on behalf of the applicant, the key difference between the Isle of Man and the UK in this regard would be who is entitled to exercise compulsory acquisition powers under the relevant Electricity Act. Under the Electricity Act in Isle of Man, that's limited to Manx utilities. In the UK, it's any electricity licence holder. I'm not sure if there, in the back of my head, I think there is a scenario where one of the parties who took forward the land rights voluntarily didn't have the backstop of compulsory acquisition because they didn't have a generation licence because of the threshold. But that is something that I would have to check. I'm not aware of any directly comparable example.
Okay, I think it would help the examining body if you did come up with a comparable example. And what we would like there is if it was not a provision in the current drafting or the drafting of the DCO that was consented, how the examining authority under the DCO regime reasoned it and how the Secretary of State decided upon it.
Amy Sterling on behalf of the applicant. We'll certainly check. I am not sure it would necessarily be a development consent order,
okay,
because the examples we've given are primarily those that are consented via Section 36 consent,
okay,
and then a separate town and country planning permission, perhaps with a grid connection, and a separate Electricity Act CPO. Because typically DCO applications, because of the administrative ease, do include compulsory acquisition powers within their application. But I don't think that's the case for all of them, so we'll certainly check.
Okay, so just on that point, it's fine. Of course, what I'm looking for is the reasoning behind it and what was relied upon in the decision making. Ms. Fernandez, did you want to come in at this point?
Yes, I'm puzzling over probably why the applicant wouldn't want CA as a fallback. So I think the more you can elucidate that position would be helpful. And so just taking that onto a practical level, and I'm thinking about Growler Bay Field where there is access and from the red line boundary doesn't go up to the edge of the field. So therefore there's an area where it's not within the applicant's red line boundary. And so therefore it has to leap across to the public highway, if I can put it like that. So what if voluntary agreement isn't secured with that landowner, what would then happen? Just talk me through the steps.
Amy Sterling on behalf of the applicant. All infrastructure landward of the transition joint bay is the subject of discussion between Manx Utilities and the applicant. Those works aren't included within this MIC application. So in that instance, obviously I'm sure Manx Utilities might have their own comments. That and the current understanding is that would be taken forward by Manx Utilities, and therefore their compulsory wayleave and compulsory purchase powers would be available to them.
Yep, maybe we could just ask Manx Utilities to confirm it.
Stephen McGee, Manx Utilities. Yes, that's generally correct, is what the applicant has just laid out in front. We have had discussions around trying to ensure any discussions were done collaboratively where there was a same landowner for land within the application and then land required to get up to the statutory highway to make obviously a more combined and joined process for them negotiations.
Thank you, Mr. McGee. I think I'm happy to move on from that point. Bear with me 1 second. I'll just view my notes. Just in terms of the actual process, so not going into update on the negotiations itself, in terms of the actual process and in terms of the certainty, and you have talked about this a little bit in terms of the certainty of the deliverability of the landfall components, you've touched upon it, but how that affects the acquisition of land and rights. Is there likely to be progress during this examination from the position you have at the moment? Is there likely to be change? Of course, we will continue to seek updates in but in your opinion, is this possibly the extent of the evidence and justification we're likely to see in examination?
Amy Sterling on behalf of the applicant. It's difficult to answer this question without going into the details. Just bear with me. Heads of terms are currently being negotiated with the relevant 5 out of the 6 landowners. I can get into the detail on that. 4 out of the 5 landowners. And they're due to be issued in written form this month, so in the next few weeks. So we would hope that we do make good progress on those heads of terms in the coming months. And of course, once those are agreed, we would update the examining body. The next stage would be to enter into the option agreement. Yeah. And again, we're looking to enter into those during the course of of this year, at least. And if, of course, that was before the end of examination, then we provide the examining body with an update at the appropriate time. So hold your thought there, because I do want to get into 6C before I get into actual updates, because there's a few that I would like you to specifically pick up on. So just in terms of procedural fairness, so we understand your position that this examination is not itself authorising compulsory acquisition. Therefore, the ECHR Article 6 and 8 safeguards do not arise in the present MIC examination. But you also acknowledge that if voluntary negotiations fail, then compulsory acquisition is your route to acquire some of those land and rights. But so the question for us really is whether the interference with land and rights and the procedural fairness is essentially being deferred to a later date and outside of this examination. Do you have a comment on that? Amy Sterling, on behalf of the applicant, our position is that it's not. That would be subject to its own legal process, which Manx Utilities and the Department of Infrastructure have helpfully set out. The applicant's really primary case for the purposes of this MIC application is that it will conclude voluntary land rights voluntarily, and that's really what's relied upon. We've been asked what if that doesn't happen, what the backstops are in terms of deliverability, which is the context which we put forward in your application. But to be clear, of course, once we get, if and when the MIC is granted, that will confer no land rights on the applicant, so there is no interference with those land rights.
Okay. And just on that point, Mr. Garden, as the legal representative of the Isle of Man government, are you content that matters relating to procedural fairness that may arise in relation to the project are being, you see what our concern is, that they're being deferred to a future date, to an unknown process, which is outside the scope of our examination, but can you satisfy us that you think that it's not going to fall between two stools?
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, we are satisfied in that respect, and I think for several reasons. I think if there were to be a change in the future which were to introduce compulsory acquisition powers, that would be subject to representations, etc. And there are, as you know, draft regulations that are being processed in relation to the change process that would address that. Similarly, in relation to the Electricity Act powers that Manx Utilities has, they are subject to consent of the Department of Infrastructure. So there is a kind of process that needs to be gone through there. It's not a case that those powers can just be exercised without that oversight and without the involvement of members of the public in that process. And I think from a practical perspective, it's quite common for kind of the planning consent element, if you like, of a project to come before the compulsory purchase element. So again, from that practical side, we are satisfied. But I think principally the reason we're satisfied is that each of the processes has effectively has oversight from the department involved.
Yeah, and I do particularly note the point that in a CPO context, the planning permission does come before the CPO. In a compulsory acquisition, of course, that's a slightly different sequence. Okay, that's helpful. And just on that point, is it just worth touching on planning balance one more time? You have given your given your response on that point, but there does remain material uncertainty before us, and so just is there a consideration in terms of planning balance for the examining body, given the uncertainty of your acquisition of land and rights necessary to deliver the scheme?
Amy Sterling, on behalf of the applicant, our position remains as we set out in writing. In terms of land and rights, we suggest that the examining authority needs to be satisfied that there's a realistic prospect of delivery and there's no obvious reason why the grid connection, the land rights for the grid connection would not come forward. We believe we've met that threshold, and therefore that in itself would not be a reason to reduce the weight to be afforded.
Fine. Okay. So now if we can turn to agenda item 7. Current status of negotiations. So one of the reasons there is nervousness around this table is because some of the negotiations have only commenced in January and February. And typically for, national infrastructure projects, even if that was not to, that would, be fine. But in the absence of compulsory acquisition within the application and your reliance on voluntary agreement is what's making the examining body a bit nervous about this and about how, how late these negotiations have started. So if you can just provide some commentary on your thinking and whether, whether you've been clear right from the start that your case for development relies heavily on exporting electricity to the UK. And if that is what has underpinned your approach to your negotiations because you feel you may not actually need it, then we'd like to hear that in your narrative.
Amy Sterling on behalf of the applicant. I don't have before me, our relevant land manager isn't here, as to the rationale as to why negotiations started in January. I have an update on negotiations as they currently are. I'm informed by Dr. Carolan that perhaps one of the reasons is that the land referencing regime in the Isle of Man is more complex. There's not a specific land register where you just go on and see who the landowner is, so that land referencing may have taken more time. However, of course, we are still sort of quite significantly in advance of construction being in 2030. So I think there was perhaps a reluctance to seek to ask landowners to sign up to option agreements which restrict their use of land so far in advance of construction and before the MIC application had progressed sufficiently through the planning system. But I would have to take that away.
I do have quite detailed questions on these negotiations. So I'm just wondering that given that this was on the agenda, you've had the agenda for since the 24th of April, why is your expert not present here?
Amy Sterling on behalf of the applicant. I have the answers to the questions that were on the agenda, but we wouldn't be able to give you very detailed responses to the status of negotiations because they are commercially confidential.
Okay. All right. So let's hope you can cover off some of these points. So I'll take 7A and 7C together. Question is, what is the realistic pathway from the current position to securing all necessarily land rights? So what would be helpful is if just using the reference numbering in your tracker, you just go through, all the landowners. What is your pathway with reference to the examination timetable? And your own delivery program. So, with respect to that, and where relevant, the delivery of other components of the whole project, if there is any kind of an overlap. And again, it's always helpful to have a clear indication of the level of confidence you have that the agreement with that particular landowner can be secured voluntarily.
Amy Sterling on behalf of the applicant. All bar one are the same. Mm-hmm. So there's 4 out of 5 landowners. I'll deal with 4 together. The 4 which are the same are landowner 1, Manx Government, landowner 3, private landowner B, landowner 4, volunteer negotiation, and landowner 5, private landowner C. The applicant has met with each of these landowners and discussed principles for heads of terms. Heads of terms are being issued in written form this month. Mm-hmm. Thereafter, the applicant will seek to enter into an option agreement based on those heads of terms. Draft option agreements are being prepared. The applicant expects to enter into those options agreement this year. The initial option period is likely to be for 2 years to ensure that the MIC is granted. If the MIC is granted, the option would then be extended for a further period of 5 years to allow the applicant to progress through, final investment decision, etc. It would then exercise the option and take an easement for the relevant land rights. The exception to that is referred to as private landowner A in the tracker. Private landowner A is a landowner at the beach option. Private landowner A has at this stage indicated they do not wish to participate in discussions with the applicant. However, there are two relevant points to note. The first is the landowner is a landowner at the beach option but not the field option. So there is always the option for the applicant to take the two cables to the field option, but also that landowner actually sits beyond the transition joint base, so is a landowner that Manx Utilities were referring to that was kind of included in the discussions to ensure there was a coherent approach, but it would be possible for the applicant to deliver the transition joint bay and the proposed development without interfering with that landowner's rights.
Okay. And should negotiations fail with any other landowner whose rights you definitely need for the project, to deliver the project, is there any likelihood of it affecting your delivery programme?
Amy Sterling, on behalf of the applicant, we're around 4 years from the start of construction, so we think there's ample time for those rights to be acquired voluntarily.
But if a voluntary agreement is not reached, then it doesn't matter where you are from the delivery programme.
Amy Sterling, on behalf of the applicant, there would become a point, I'm not sure we've identified when that point would be, in the next 4 years, the applicant would have to look at the other options that we've referred to.
So the answer is no.
Amy Sterling, on behalf of the applicant, the answer is no. We're confident the land rights wouldn't affect the delivery programme of the Island Link if it were to be brought forward.
Okay. All right. So that, I think, covers off 7A and C. All right. Let's just move on to B. And I think what we are seeking here, and I don't... What I'm seeking here is something the equivalent of statement of reasons, which is to just explain what works numbers. And I know you very helpfully provided maps of the landowner boundaries, but what works numbers will be required? So what explanation you just gave me with respect to the landowner at the beach option would be really helpfully demonstrated with something the equivalent of a statement of reasons. So do you have that for us?
Amy Sterling, on behalf of the applicant, we have a draft in preparation.
Okay.
I didn't think we were going to run through it today. We have a draft where we've essentially overlaid the works numbers on the relevant land holding.
Okay.
And we were intending to submit that as part of the updated land rights tracker at deadline 4.
Fine. Can I make a suggestion that if it is being prepared in draft, can that be a hearing submission? By hearing submission, I do mean this week. I don't want to create a further deadline.
Amy Sterling, on behalf of the applicant, yes, I just asked my colleague to check that the relevant land person
You can tell us after lunch.
Yeah, can update it. Thanks.
Bear with me one second.
So something that would be quite helpful to understand, accepting that we're not looking at compulsory acquisition, but being mindful of the fact that Groudle Bay Beach is the proposed landfall location and construction activities are in close proximity to those caravans, those units of residential development. how are you thinking about their rights in terms of noise and effects on them during the landfall, and where is that set out? And access and so forth.
Amy Sterling on behalf of the applicant. They are Girdle Bay holiday cottages. They're temporary holiday accommodations. They've been assessed within the EIA. I would have to check if any specific discussions I've had with the owner of those holiday cottages, noting they are short-term temporary lets.
Yeah, so and ordinarily in a DCO application, then we'd be looking at category 3 rights, and there would be something about the effect on their rights. So I would like to have something which sets out how you're proposing to approach that.
Amy Stilling on behalf of the applicant. We can certainly consider. I'm not entirely sure I'd agree that there was they would fall within Cat 3 injurious affection, but I take the point. We can set out how if and how discussions have progressed with the owner.
And just as a follow-up, and you may or may not know the answer, are they definitely temporarily occupied? And we've been up and down there several times, but do we know that for sure, or is that an assumption? When I say temporarily occupied only for some part of the year.
Amy Stelling on behalf of the applicant. Dr. Caroline is informing me that we have seasonal information for the occupancy of them, which confirms that those which are located towards the beach are temporary holiday accommodation, but there are some towards the road which are permanent. Amy Stelling on behalf of the applicant. I don't want to give you false or misleading information. I think it's something we'd probably have to get really specific information on and provide in writing about the holiday cottages.
And possibly in that respect being alive to, and I don't pretend to know, the equivalent provisions under Isle of Man Town and Country Planning Act in relation to residential dwellings and immunity from enforcement. But if there are essentially unlawful ongoing uses, for all year uses in place, are those still in a position where they are capable of enforcement against them, i.e. they continue to be unlawful, or have they moved beyond the period at which relevant enforcement could be pursued, and so therefore they are de facto established all year uses? It's worth looking at that, because obviously if they have moved into the general dwelling stock, even if that was inadvertent and even if that was pursuant to originally not permitted use, nevertheless they are still then all year round dwellings.
Amy Stelling on behalf of the applicant. I understand the point you're making. We'll certainly check that to the best of our ability.
Can we note that as an action? Thank you.
Sorry, Mr. Hyde. Just on that note, it would be extremely helpful if you would provide a note that covers the matters we've just been discussing, but also just draws out what the proposal is for managing the various different impacts that those dwellings would experience. And some of it will, of course, be in the application, other bits may not, but if you would signpost where things are and then add in where things may not be.
Amy Stelling on behalf of the applicant. Yes, of course.
And just at risk of further prolonging that, but we've obviously focused there on the holiday bungalows that we have observed on site. But I'm just conscious that we need to be clear that we're being complete, and we do have some other land holdings there, including, for example, the tourist railway, and I would like, therefore, to extend the remit of a check to basically be the equivalent of a Category 3 check, so that we just look at any other directly or closely adjacent land holdings who might be entitled to make a relevant claim, so that essentially we're not leaving somebody out by accident.
Amy Stilling on behalf of the applicant. I'll have to check if the concept exists here in terms of, diminution in value by the presence of the scheme and fumes, etc. I don't know if those principles exist. I think we'll have to take that away and consider it. But alternatively, we could seek to define, a zone of influence, with the examining body could say in the written questions, here's the spatial area that we would like to understand how you've considered the impacts on them and what discussions you've had with them.
Yeah, you're nailing the point as a point of principle, and I'm not going to pretend that I understand the answer to the injurious affection or equivalent possible rights in action point in Isle of Man law, because I don't know. But it'd be good if somebody found out.
Thank you. That's an action.
So in summary, we're looking for a comprehensive pulling together of the effects on people and tourist functions in the Grudel Bay limits, how they've been addressed in the ES, any additional information that would be helpful for the examining body to understand the construction impacts on temporary and permanent access for their properties, and the full round picture of what that looks like. Is that okay?
Amy Stilling on behalf of the applicant. Yes, it's clear.
Thank you. Ms. Newton, I believe you had your hand up. Do you still have a point to make?
Sorry, I was just looking up the planning applications for Growdell Bay Village, and certainly there seem to be different numbers given in the planning application, but the top 12 original holiday cottages nearest the King Edward Growdell Road, they have permission to be permanent residences. The rest are meant to be holiday cottages, but I haven't got time at the moment to look up to the conditions, because some holiday cottages are given consent subject to them being able to be used as residences over the winter period, and as long as they are only occupied for no more than a month during the summer period. So I would have to check up the application details to give you that, but there's somewhere between, there's about 12 permanent, and then 1, 2, 3, 4, about 20 are holiday cottages.
That's very helpful information, Ms. Newton. Thank you. Okay.
And perhaps, just to follow up that point, if you would have a look at the information Ms. Newton was just looking at and add that into the note, so that gives us, and also a plan. I know we're adding to that little list, but I'm looking at it now on my screen, but I think it would be helpful to identify which properties we're talking about, provided it's in the public domain.
Amy Stilling on behalf of the applicant, just so I'm absolutely clear on timescales, the intention was to submit the works plans the landowner plans overlaid with the works plans and that description ideally tomorrow as part of a hearing submission. This further work in terms of investigating the ownership of the others, which just has to be for deadline 4.
Yes, Ms. Sterling. So that about the holiday cottages, that's definitely a hearing action. So due at deadline 4, what we're asking for is the statement of reasons equivalent, which you said is in preparation already, for that to be submitted as a hearing submission this week.
Amy Stilling on behalf of the applicant, again, sorry to labour the point, the land rights tracker is their equivalent of the statement of reasons, so an update to that document tomorrow.
It is an update to that document, but with identifying how each parcel of land or each affected landowner, why you need their land, which is why I'm calling it the equivalent of a statement of reasons. Yeah? Okay, thank you. And you're going to update us after lunch on whether that's possible this week or not.
Yes, they're checking now. Thanks.
Super, thanks. Okay, so then we'll move on to agenda item 8. This is the funding statement, and it confuses me considerably calling it the funding statement, given you don't have compulsory acquisition. So let's come to, the naming of this document at a different time. But it's just worth saying, and Mr. Smith, this will be of interest hopefully to you because it covers some of the points that you raised before the break. So, but a lot of parties have interest in this area, and the matter that we're interested in is the extent to which the project is financially viable and deliverable. And the reason this is important to test, because again, you are asking the examining body to place substantial weight on the public and economic benefits of the proposed development. So we need to understand the degree of certainty associated with the deliverability. And it's not just the deliverability of the project for you to, realize the benefits of the project, but it's also, to be able to deliver on the mitigations that you've committed to. So we're not seeking commercially confidential information, which is not relevant to the examination. So our line of inquiry today is definitely about the different sources of funding and the degree to which certainty is associated with some of those sources of funding, and what it is going to fund. So the proposed development, the whole project, the decommissioning, etc. So what is it funding? And then ultimately what weight can reasonably be attributed to the claimed benefits of the proposed development, and that that's the summary point. So just looking into agenda item 8, A and B, the proposed funding mechanisms do come across as quite indicative and uncommitted, reliant on future decisions, external factors, including the MIC being granted, final investment decision by shareholders, and of course contracts for difference, which you've brought up again at SIH 5, and we deferred to this hearing. So just can you explain to us with timescales how the funding of the proposed development will be secured in practice?
Amy Stelling on behalf of the applicant. Yes, so following well, first of all, I think it's important to know, if we could take A and B together, I think they're certainly linked, is that the funding of the project's development expenditure, so the carrying out the surveys, the preparation of the MIC application, the funding of the process that we're in, has the rolling support of the parent company and is budgeted annually. There would then be a future step, which is to move towards the funding of the construction expenditure, which we've indicated to be around £5 billion, and that would be subject to a future final investment decision. And in terms of the timescales of how we get from a commitment to fund the DevEx, which is where we currently are, to a commitment to fund the CapEx, which is where we're heading, that would only ever be taken following an award of the marine infrastructure consent. You would need your consent to be able to take a final investment decision. So following the MIC consent, the applicant will progress the consent application for the EIST. 12 months.
Sorry, just slow down a little bit.
Sorry.
Do you mind terribly? Because I have a couple of questions. So if I just stop you there. So you talked about the rolling support, and you've talked about the 5 billion construction, which you will get permission after consent, for the construction, the CapEx expenditure. So I'm just going to go back to some of the discussions that happened yesterday, where pre-construction surveys were some of the things that you've mentioned. So, there's a big component of some of that baseline study that relies on this rolling funding. So do you have that commitment that you can show to us or give us some certainty about that rolling funding that you have?
Amy Stelling on behalf of the applicant. I'm advised that pre-construction surveys form part of the DevEx, so yes, they're part of the currently approved rolling budget.
But do we have that evidence before us that you have that approval and that will carry on for the next 4 years till you start the construction?
Amy Stelling on behalf of the applicant, we have told you that we have that approval. What specifically would you be looking for in terms of evidence?
Some commitment from your parent company, which can be relied upon.
Amy Stelling on behalf of the applicant, we can certainly take that away. It's not currently before you, but we can certainly take that away.
Yeah, okay. And just I mean, just for future reference, it's something you've said before. You know, I think anything that you are asking us to rely upon in terms of our examination, we'll probably need to see as evidence rather than you just telling us that it has been secured. So, but yeah, we do appreciate that you're going to take that away as an action. Okay, then the construction. Just hold on that, the WebEx component, the CapEx component, my apologies, WebEx. What does that include? Does that include the whole project or just under what's approved in the within the order limits?
Amy Sterling on behalf of the applicant. The CapEx, capital expenditures of the whole project, so as we set out, that is approximately £5 billion. That's how much it would cost to construct the whole project. You asked her how that would be split. It's approximately, with some rounding, 60% to the proposed development and 40% to the EIST, so approximately £3 billion in construction expenditure to construct the array, approximately 100 million to construct the island link works, and approximately 2 billion to construct the EIST.
Okay, and does this include decommissioning?
Amy Sterling on behalf of the applicant. No, that would be a separate budget known as DevEx.
So something that has been raised at public meeting 2 is that you talk about decommissioning, but if the funding for that is not secured, one of the points that was raised on the floor was that, you know, whether Ørsted would even be there. So, you know, how, first of all, is it important for that reassurance to be provided to the government, to the examining body, and to, you know, members of the public? And if it is, then how do you provide that reassurance?
Amy Sterling on behalf of the applicant. The government already has that assurance because it's a requirement of the agreement for lease that a guarantee for decommissioning obligations is in place. In terms of the planning process, the applicant is currently in discussions with the Department of Infrastructure on appropriate wording to update the decommissioning requirement to include further information on what the decommissioning programme and the decommissioning plan should contain, which have to be submitted in terms of the decommissioning programme prior to construction of the works.
Okay, so what format will that take in terms of the examination?
Amy Sterling on behalf of the applicant. It's expected to be an update to the decommissioning requirement, which is currently in the MIC, to add greater specificity on the decommissioning programme, potentially also some updates to the outline decommissioning plan, which is currently before you as well. But these, I said, we're still discussing with the Department of Infrastructure what information they would like to see from a planning perspective, given the obligations under the EFL. And we're making good progress. We're expecting to provide a further update to the MIC at deadline 4.
So, I mean, in terms of the decommissioning plan, it's, you know, given it is so many years, you know, everything is going to change. You know, you can't provide a certain level of detail in that. But I think what we're looking for is that certainty that you'll be able to, you will have the means to be able to decommission the project, and that, you know, one of the concerns that's been raised is that there won't be stranded assets left. And I don't know, I still feel that reassurance is not before us, and I'm not entirely sure how you can do that through the requirement. But if you want to talk us through that.
Amy Sterling on behalf of the applicant. 2 things is there wouldn't be any stranded assets because the agreement for lease would require a decommissioning guarantee to be in place. Okay. So it's quite common, and it's certainly the case in all offshore wind DCOs, for example, that any decommissioning obligations sit outside of the planning process in terms of providing security for decommissioning. If you had an onshore wind farm, it would be common for the lease agreements with the landowner to have the decommissioning security, not the planning permission. Okay. That's the circumstances we find ourselves in. However, we have a requirement which says that prior to constructing the relevant works, we have to provide a decommissioning programme. Okay. The discussion we're currently having with the DOI is what that decommissioning programme should contain, and one of the topics of discussion is information on decommissioning security,
Okay.
and that is the wording that we're looking to reflect in an updated requirement in the MIC, so that there's double protection, as it were. There's protection under the agreement for lease in terms of a guarantor, in terms of decommissioning security, but also a requirement under the MIC that information on decommissioning security has to be provided before the construction of any works.
Okay, so basically what that security is you're saying is not necessarily before the examining body, doesn't need to be before the examining body, as long as it's agreed that it will be provided to the relevant authorities at the time.
Amy Sterling on behalf of the applicant. Yes, I would say that correct. There might be some wording around, acceptable form of security or something like that. Okay. That's what we're discussing with the DOI.
Okay, so let's just get a comment from Mr. Garden on that. Are you generally satisfied with the applicant's approach to decommissioning and the securities that you have through the draft MIC?
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, I think Ms. Sterling has effectively characterised what our position is, that we are in discussions around decommissioning. So what is in the draft MIC at the moment is not what will be there probably a deadline for, and the position in respect of decommissioning will move on to reflect those discussions and to address matters like security. And as you've alluded to, we're very conscious of kind of some of the messages as well that have been relayed, so that will be in our minds when we're having those discussions.
Okay, thank you, Mr. Garden. And I think because decommissioning is a matter that has come up quite a lot, not just in PCRs, but at public meeting, I think it'll be really helpful if an update on that, an agreement on that point, is consistently a part of the statements of common ground, with specifics around all the points that you have put before us today, which is the decommissioning plan, the related requirement, and the decommissioning security. And that all matters are agreed between government and yourselves.
Mr. Garden, on behalf of the Department of Infrastructure, will certainly take that forward through the Statement of Common Ground.
That's excellent. But if we could just note that as an action, that would be great. Yeah, brilliant. Thank you. I'm just going through, I think there might be some comments from my colleagues. Bear with me 1 second.
So one of the things that we were just considering is in the scenario that the applicant is not owning this scheme and it's sold on to another party in the fullness of time, and when decommissioning comes around, it's nothing to do with Orsted. Is the AFL capable of being transferred to any other party?
Amy Sterling on behalf of the applicant. I don't have that information in front of me. I would have to check.
Maybe DOI, Mr. Garden, you might have a view on that.
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, I will have to review that. I don't have a copy of the AFL in front of me, but we can certainly provide that information.
And just sort of pin back to the specifics in the draft MIC there, obviously Article 6 contains fairly standardised form of drafting found in multiple DCOs in relation to transfer of benefit in whole and or in part and or of lease. So there is clearly an intention in forming the MIC to be able to transfer benefit in whole or part for a term of years or entirely. But yet if the AFL does not permit that, then kind of sets the intention of that article at a measure of risk, shall we say. So yeah, it would be really useful to understand if there is any interactivity or limitation possibly placed on what ought to be provided in the MIC arising from the AFL. And particularly this issue around the transfer of part 2 is most important, because in terms of looking at the prospective onshore connection to the Isle of Man, one of the means of delivering that might be a transfer of part of benefit for maybe a period.
Amy Sterling on behalf of the applicant. Yes, in the current scenario, the likely operation of the transfer of benefit of the article would be to transfer the island link works to Manx Utilities. Just to be clear, those aren't currently the subject of the agreement for lease. The island connection, the agreement for lease area is the array area, albeit before the developable area approach. The transfer benefit orders, of course, article is commonly relied upon for offshore transfers. In the UK, it would be a similar scenario for the island link works. And of course, in that scenario, the provisions in the article operate to ensure that any person who takes the benefit of the article is also subject to any obligations associated.
So if I might just link that last action back. Earlier in the week, we were talking about the AFL, and you were going to have a chat with DOI about what would be possible to share or not. And I think in those conversations, if you would also think about that question of transferability and kind of signpost us if it's not immediately obvious, that would be great.
Amy Stelling on behalf of the applicant. Yes, noted, of course.
Thank you, Ms. Sterling. So I did interrupt you mid-flow, but we've got the split that you provided between your rolling support, the CapEx, which you said is split between the island works, and then 40% and 60% between the order limits and the EIST. So it covers everything. So I'm clear up to that point, and then decommissioning is a separate fund, and that's all being covered through all of this. So is there anything else in terms of the funding that you'd like to explain here?
Amy Stelling on behalf of the applicant. No, if you're satisfied with the answers I've given to date, then nothing further.
So I do have a few more questions. Is the reliance on contracts for difference? So what role does the contract for different award play in your deliverability of the project?
Amy Sterling on behalf of the applicant. Yes, it's currently part of the applicant's business case assumptions that it will benefit from a contract for difference. It would be common for an offshore wind project in the UK to bid for a contract for difference before taking a final investment decision. The Isle of Man government, along with other Crown dependencies, is currently in active discussions with Ofgem and DESNZ on the availability of the contract for difference to offshore wind projects which are located within Crown dependencies. Those discussions are progressing well. In the King's speech yesterday, he announced an energy independence bill, which is considered an appropriate vehicle to ensure that the Crown dependencies can participate in the CFD's auctions, but it's certainly currently part of the current business case, yes.
So the question is two things. One is you did talk about the scale of the project, and the amount of energy you're generating is going to be a part of what makes you a competitive bidder. So just tell me a little bit about that. And the second thing is that how reliant are you on the CFD being secured, and what does that do to your business case if CFD is not secured? And the third point is that does the fact that the array itself, the generating asset, so to speak, is outside of UK territory, will that make a difference to your competitiveness?
Amy Sterling on behalf of the applicant. They're not questions I'm able to answer, madam. Those relate to confidential bid strategies for CFDs, which are highly competitive processes. I'm not aware of any other planning process being sort of contingent on the applicant providing its bid strategy for CFD. I understand the points you're making. I'd have to take them away to understand. Frankly, I'm not privy to the information you're asking, so I don't know the answer. So I'd have to take the question away, see what, if anything, we can say in the context of examination.
I think just for the last point about, how competitive are you for CFD, given that the generating asset is outside of the UK, if you could just look for precedents. So I completely understand that this will not, how competitive you are is, of course, outside of your remit. I understand that. But in terms of precedents, the information that you can tell me is that how reliant is your business case on the CFD being granted? So if, for instance, you don't get granted it, then where does that leave you?
Amy Stelling on behalf of the applicant. There is no precedent because it's not currently permissible in the CFD regime. It's for Crown dependencies to participate, which is the discussions that the Isle of Man government have been having with DESNZ and Ofgem. So assuming that energy independence bill moves forward and discussions remain as positive as they have proven to date, we expect that the project will be able to compete in a CFD, and therefore the fact that it's in Isle of Man territorial waters we expect would be irrelevant to its competitiveness.
So that point would be, the relevance of that point to this examination will depend very much on the answer to my second question, which is how reliant is your business case on the CFD?
Amy Stelling on behalf of the applicant. Again, I don't have that information. I would have to check.
Okay, so let's take that away as an action, but it will be two actions. So one is how reliant is your business case on the CFD? And I am looking for, and as I've said before, supported by evidence, I'm looking for numbers. So, you know, is it 30% of your, you know, whatever you're hoping to spend on the project? And I'm really looking for that. If you don't get CFD, then the project will, you know, move forward regardless, or it would stop in its tracks. So that's one thing, and all supported with evidence, if possible, please. And then the second point is that if it is reliant on CFD being granted, then I think we will need more information on how further along you are in that process in terms of having those conversations and, you know, being able to actually bid for it. And we will need a full update on that. So you can take that away as two actions.
Amy Stelling on behalf of the applicant. Amy Stelling on behalf of the applicant. My colleague has reminded me that it would also be helpful if you could ask the Isle of Man government for an update on their progression of the availability for overseas crown dependencies to participate in the CFD, because they are leading the discussions with DESNES and with Ofgem.
Did you say they're leading on it?
Yes.
Oh, okay. Yeah, that'll be really helpful. Please do, Mr. Mull.
Just verbally, just to confirm, those discussions are ongoing and very positive so far, but we'll come back in a written response more accurately for you.
Okay, so if you can stay. So, Mr. Milne, that's helpful. And if you can stay in touch with the applicant, because the importance of your response and the level of information we need is going to depend greatly on the applicant's reliance on the outcome of that process.
Yeah, Ken Milne for DEFA, yes. We'll liaise with the applicant. Thank you.
All right, thank you. Anything further from DOI on this? Mr. Garden?
Robert Garden on behalf of the Department of Infrastructure. No, nothing further on that. I think DEFA are leading on that engagement and best placed to provide the updates.
Excellent, thank you. Okay. So we've talked about the commitment from the parent company in terms of the rolling budget. You're going to go away and look at that. We've talked about this. So I think we've covered off up till 8C. We've covered 8D as well. 8E, I wonder if that'll be implicit in some of the responses that you are going to provide us, not the ones that you have given. But it is still worth actually asking DOI, as, you know, landowner of the seabed, whether, you know, how comfortable are you with the level of funding the applicant, or the certainty that the applicant has given you in terms of the funding available to deliver the project? Are you looking for more? Would you, you know, or is this enough?
Robert Garden on behalf of the Department of Infrastructure. I think in terms of the department, there is the agreement for lease, and that's been narrated a little bit, and we will provide an update on that. But in general terms, we're satisfied. And again, in terms of the process in relation to construction, etc., that Ms. Sterling has talked through, that aligns with how projects have been consented in UK waters. So again, we're satisfied from that perspective. The one element from the department's perspective that we are still looking at is the decommissioning. and how that is treated within the draft MIC. But beyond that, I think we are comfortable.
I think in that regard, Mr. Garden, there were three things that I highlighted one day. There was the decommissioning plan, the outline decommissioning plan. There was the requirement that secures it, and the guarantee. There are two things before us. One is the requirement, and the second is the management plan. I think if you agree it before the next deadline, then it's fine. I don't think I need anything further. But if you don't agree it, what would be really helpful is if we could have your comments on the plan itself. What we've asked other parties to do through this examination is actually submit a track change version of what you would like to see changed, or a schedule of changes, whatever's most convenient for you. Then if you could submit that at deadline 4 if those matters are not agreed.
Yeah, Robert Garden on behalf of the Department of Infrastructure, noted, and we'll take that action forward. Thank you.
Yeah. Yes, thank you. Do any other parties have anything further to say on agenda item 8? Okay, I don't see any hands up. The time now is 11 minutes past 1. We will break for lunch. If I could request everyone to be back at 2:15, please. Thank you. Good afternoon, everyone. Time is now 2:15, and we'll resume session 3 of SIH 7. So this session is to examine a few provisions under the draft marine infrastructure consent. But I'm very mindful that there were a few people who were attending the hearing primarily for agenda item 10, and I just want to make sure with the case team that they have joined back the hearing. Mr. Randall? Sorry. The persons who were going to join for agenda item 10, are they back online? Okay, great. Okay, so let's start with agenda item 9, and perhaps if parties, DOI and applicant can just start by giving us an update.
Toby Yates on behalf of the applicant. Yes, the applicant's in discussions with the DOI around the drafting of both Article 17 and 21, and we've been responding to their representations. A summary of the applicant's position is that until the proposed bills that have been brought forward have been approved by Tynwald and granted royal assent, the applicant maintains that Articles 17 and 21 are necessary to fill what at the moment are considered to be legislative gaps.
Anything further from yourself? I know that this is likely to be the changes to the MIR are likely to come forward in July, so before the examination closes, so in time for the last version of the MIC to be, to have that revision. But is there anything further from you in terms of those timescales? Sorry, Mr. Garden. I'm looking at you, but I didn't say your name.
Yeah, thank you. Thank you. Robert Garden on behalf of the Department of Infrastructure. I'll take each of the articles in turn. In relation to Article 17, which is the safety zone article, that legislation requires an application order to be approved by Tynwald, as we discussed in the previous specific issue hearings. The expectation is that will be laid in July. So the department is progressing to work to that timeline and expectation that legislation is in force in July. So in time for this examination. And the drafting that we will progress will reflect that. And you've seen our representations that we think once that legislation is in effect, then it should be that takes effect as opposed to the article. But we will continue to work with the applicant in that respect. And then in relation to Article 21, which relates to the non-material change process, again, the consultation on that has taken place. The relevant legislation will go through the negative resolution procedure. The expectation is now that will not be laid in Tynwald until October 2026. So there is a change to the previous timeline as advised, but it will be made before the end of the examination. So the form of those regulations will be known. And again, we will prepare drafting that we would like to see in the MIC, and we will continue to work with the applicant in that respect to deal with that. And ultimately, if there is a gap, we feel that's something that the Council of Ministers can deal with in the final decision if that comes into place after the close of this examination.
So with the non-material change, it's unlikely that will be that you will you'll leave Article 21 in the draft MIC in its current form then?
I think Robert Garden on behalf of the Department of Infrastructure, we will propose alternative wording because the regulations will be enacted in July but laid before the Tynwald in October. So we will propose wording effectively on the basis that we don't think Tynwald will that the legislation will take effect.
Has that wording been shared with the applicant?
Not as yet. So that's wording that will be shared with the applicant, and we'll continue to work with them in relation to the drafting of both of those articles.
Is there a likelihood for the changes relating to safety zone to also get delayed from July? Because at your last submission, the changes to the MIR with respect to non-material changes were also expected in July. So is there a likelihood for any further delays?
Robert Garden, on behalf of the Department of Infrastructure, we don't expect there to be, on the basis that the regulations will be made in July, and the consultation draft in relation to safety zones had draft regulations. We've received comments on those from the applicant, so we don't expect any delay in relation to the safety zone provisions.
Okay, so then, Mr. Garden, if you could share the proposed changed wording for Article 21 with the applicant, and if perhaps by deadline 4 I could have an agreed position with regards to that, both in the draft MIC and in your statement of common ground, that would be grand. Okay. You did mention consultation briefly, which kind of touches upon the first point in my agenda, which is if there were going to be changes to the, the changes to the MIR, if there are any consultation requirements. You've sort of covered that, but just confirm that response for me.
Mr. Garden, on behalf of the Department of Infrastructure, so there's been consultation on the draft regulations already. Those processes ran between March and April in relation to both sets of regulations. So that consultation has taken place. We wouldn't propose that there would be any future consultation included within the draft MIC.
That's understood. But my question was more with respect to any changes to the draft MIC if it happens after the examination. Sorry, so with respect to the delay in regards to Article 21, would there need to be any further consultation with any changes to the draft MIC, because given that the changes to Article 21 will happen after the close of the examination? Or
yeah, Mr. Garden, on behalf of the Department of Infrastructure, I don't believe there would be, because the regulations will be out in July. It's the TIMOL process that is likely to take place in October, and the drafting that we would propose to include in the draft MIC would deal with a situation where the regulations took effect after the close of examinations. I don't think there would be any further requirement for consultation in that respect.
Okay. All right. And this is just a belt and braces point. Removal of Article 17, of course, is likely to happen before the close of consultation. And you are both in agreement that removal of Article 21 and, of course, now Article 17, and, of course, now Article 21 is not getting removed, but it will probably get edited. There are no further consequential changes to the draft MIC.
Toby Yates on behalf of the applicant, that's correct from our perspective.
Fine. Okay. Yeah, I have nothing further on this. Do DEFA have any points, or are you content?
Ken Milne, representing DEFA. No, we've no comments on that.
Okay, great. Okay, let's move on to Schedule 2 and 4. So the examining body notes that the applicant has now removed the deemed approval provisions from the draft MIC, and DOI has generally welcomed that in principle. But are there any, and perhaps if the applicant and DOI can respond to this, any residual risks that remain with the approval process?
Toby Yates on behalf of the applicant. No, the applicant doesn't consider that there's any residual risk with the DMIC as it's currently drafted, and that's D3010, and that's because following the removal of the deemed approval provisions, that's been replaced by a bespoke appeals process that's now included at Schedule 4 that provides that process in absence of deemed approval.
Okay, so if there was, for instance, a significant delay with approvals, that backstop is there in the draft MIC in the bespoke approvals process?
Toby Yates on behalf of the applicant. Yes, that's correct. So if you look at paragraph 4, subparagraph 1 of Schedule 4, that sets out the circumstances when an appeal may be brought. And you'll see at deadline 1 that was extended to include subparagraphs E and subparagraphs F.
Yes.
and effectively they were the provisions that previously benefited from deemed approval.
Right.
Now deemed approval has been removed. That's
So
been
that's
brought
been
into the
brought
framework of the appeals process.
Understood. Okay. And then, are there, yes, so is there any material implications on the delivery of the project?
Toby Yates on behalf of the applicant, no, we're comfortable with the timings and then the backstop mechanism in the appeals process. Thank you.
Okay. Looking at agenda item 10B, so the appeal timeframe. So we have covered this. There is a distinction. There's still a conflict on the amendments to the determination and appeals timeframe and the pre-notification period. Have you moved any further on this point on reaching agreement with DOI?
Toby Yates on behalf of the applicant. We're still in discussions with the DOI and expect to be able to provide an update at deadline 4. The latest position at the moment is, you will have seen, I think, since the agenda was released, that the applicant's provided a detailed response of its position in D3003, and this specific reference for your benefit and the DOI, that's in response to D2-029-001. So that's the DOI's submission that we've responded to.
Yeah. So just on that point, if agreement is not reached, I just need to understand that just in terms of precedence, what is generally the timescale in, for instance, a made DCO?
Toby Yates on behalf of the applicant. So the applicant's position of retaining 8 weeks discharge period for effectively the onshore elements or requirements, and then 16-week discharge period for offshore. That's consistent with various DCO precedents, including Hornsey Project for Offshore Wind Farm Limited, and obviously that's known by the applicant, but it's also the precedent that the DOI had pointed towards as well in some of its submissions. It's also consistent with Five Estuaries Offshore Wind Farm and Morecambe Offshore Wind Farm, just by way of some examples.
And if you were to change those timeframes to the ones suggested by DOI, what are the likely implications in terms of delivery program for yourselves?
So my instructions, Toby Yates on behalf of the applicant, my instructions are that it's an unacceptable risk to delivery program. And I think linking all these points together, that's where it's important to note that we've removed the deemed approval mechanism. So at the end or expiry of that period, in the event of non-determination, for example, the applicant would no longer benefit from deemed approval at that point. They'd then have to follow an appeals process, which has additional time implications. And I think on that as well, the DOI had requested for advance notice of when applications for discharge are being brought forward. The applicant has built that into its DCO as well, and you can see that at paragraph 2, subparagraph 1 of Schedule 4. It's obviously in the applicant's interest as well to make sure that sufficient advance notice is provided so that the DOI has sufficient resource to deal with the applications. So I guess summarising that all together, the applicant's position is giving advance notice, having time periods that are well precedented, and then substituting an appeals process in absence of deemed approval. We've gone far enough to ensuring that there's that balance of deliverability certainty for the applicant, but also enough time for the DOI to process that.
But also in terms of advance notice, I think I remember there being a conflict with DOI in terms of the amount of advance notice. Have you met the DOI on that requirement?
Toby Yates on behalf of the applicant. No, because again, it's just an unacceptable administrative potential delay to the delivery programme. And I suppose this is where we rely on the precedent that I've referred to there. The principle of securing advance notice isn't secured in those DCOs, so we've gone above and beyond. So the fact that those other discharging authorities could discharge applications within that time period without advance notice, we feel it's reasonable for the discharge to occur with those same time periods when advance notice has been secured as well. But as I say, it's in both parties' interest to ensure that sufficient advance notice is provided.
Mr. Yates, just a couple of points. This is the first MEMA application under MEMA and the first if it was granted the first marine infrastructure consent. So I think there will be some places where a certain exception might be required, especially given the resources that the Isle of Man government has, or indeed the fact that they will be doing everything for the first time. So your definition of above and beyond and what is good enough might not necessarily apply here. So just bear that in mind. And so when you're giving your justification, it might be helpful to just have that, that understanding that this is alongside the Isle of Man government. If this was to go ahead, you're setting a bit of a precedent. So, it's a new experience for everyone. Let's get some comments from DOI on this, because I think there is potentially, and as tends to be with a lot of the DCO examinations, is that if there is a remaining, if the matter about timescales is not resolved, it is then up to the examining body to determine what timescale it puts, at least in the recommended marine infrastructure consent, to the Council of Ministers. So I just want your justification as well. First of all, can you just actually talk about that unacceptable risk? I appreciate that that's an assessment for the applicant to make, but it would be really helpful to understand how you feel that what is your assessment of that? Do you feel that that is achievable?
Yeah, thank you, Madam. So Robert Garden on behalf of the Department of Infrastructure. I think firstly we welcome the removal of the deemed approval process and the inclusion of a bespoke appeal process, and welcome the work that the applicant has done in dealing with that. And we agree in relation to your question on residual risk that there is no residual risk given the fallback that exists of the appeal process. And I think that probably addresses your question in relation to material risk for construction program. In terms of the timeframes and the deadlines that the department has suggested, I think we set these out in the deadline 2 submission, which you've clearly read and understood, and we've asked for effectively a 12-week period in relation to matters for onshore requirements, and then a 6-month period in respect of requirements that deal with offshore matters. And again, we will continue to work with the applicant to try and reach agreement. In terms of precedent, I think for the onshore elements, there are DCOs that we would point to. The Mona offshore wind farm, for example, has a period of 13 weeks for discharge of requirements onshore. And in relation to the offshore requirements, one of the matters we raised last time is that a lot of the conditions are more akin to what you would see in a marine license traditionally. And in a number of cases, in particular the Hornsey 4 example, the MMO is given a 6-month time frame within which to determine those conditions. So there is precedent that we will point to there. And I think it's worth noting, you've already picked this up, but there is a substantive amount of information that will be submitted to the department, both onshore and offshore. So it's got responsibility for discharging both sets of requirements, and it will be the first set of requirements that do come through. So we do think there is justification for those timeframes that we're asking for. And then,
sorry, carry on, Mr. Garden.
No, happy for you to go with another question.
Sorry, what's that?
So, sorry, I think we crossed there. So in terms of pre-notification, which is the other element, again, we welcome that the applicant has included this, and it's effectively a matter of resourcing for the department that this has been requested, and we've set timeframes out again in the deadline 2 submission for what we would like to see in relation to the draft MIC, and effectively, I don't think we accept that would cause an additional unnecessary burden in practice, and it would benefit the department if they were given sufficient notice so that they could ensure they have resource available for requirements. And without thinking about what may be in the form of MIC, there will obviously be requirements that span a range of technical disciplines as well that require consultation with a range of consultees. So that the request that we have there is effectively to provide in relation to those requirements not less than 8 weeks advance notice of the submission of the requirements. And we've also included in this, I think this is one area that we don't have agreement with the applicant yet, but a further request that there's pre-notification before any appeal is actually submitted pursuant to the appeals process. And the reason for that is effectively if there is something that has not been determined but is close to being determined, it's formalising that and ensuring that there's a notice period so that perhaps we can avoid an appeals process if necessary.
Mr. Yates, I think there's a few things there that, I think that it is in the benefit of the applicant if the department is saying that they need that advance notification to resource up in order to, discharge some of those requirements. It is in the applicant's benefit to perhaps give it that notice. And it's not like you will talk to them at 8 weeks. They'll probably have you're probably going to have some ongoing engagement, so it doesn't feel to me like it's going to be, as you put it, an unacceptable risk or an unacceptable administrative burden. If you're unable to say anything or agree anything different to what you've already put in examination right now, it's fine. But I would ask you to take that away and just think about the benefits of being able to do that, accommodate these requests. The second thing, that if you're unable to accommodate these requests, then just please bear in mind exactly what I've said to Mr. Garden, that if it was, left unresolved and the examining body does put it in the recommended marine infrastructure consent, then what is the implication for you? We'd like an explanation on that as well, so that we can take that into account. And of course, all supported with evidence.
Toby Yates on behalf of the applicant, that's understood, and we welcome continued engagement with the DOI.
Okay. Okay, I think I'm quite content to move on to agenda item 11. Are the parties who'd left the examination back for this? Okay, good. So agenda item 11 is on protective provisions. Once again, apologies just for for ease of language. I'm still using that term, although I appreciate that there aren't any protective provisions for these parties. I appreciate that you have introduced others. Agenda item, the first bullet point you've covered in SIH 4 already, basically on your position on the need for protective provisions, but it would be really helpful. Ms. Grange, have you put your hand up to say something now before I finish what I'm saying?
Have, if that's okay, ma'am.
Go on.
Samantha Grange from Evershed Sutherland, here to speak on behalf of BAE Systems Operations. We did just want to make a couple of comments in relation to some of the requirements in the marine infrastructure consent. I'm not sure if that's an appropriate time to do that now.
What requirements are you talking about? Because when we get onto management plans, I know it's talking about management plans, but we are actually still in the marine infrastructure consent area. So I'm just wondering what it is that you want to talk about and whether that's best covered under 12.
Well, we just wanted, Samantha Grange for BAE Systems Operations Limited. We just wanted to summarise for the examining body, if that would be helpful, the status of discussions in relation to some of the aviation-related requirements within the marine infrastructure consent.
And are you talking about requirement 15 and 14?
Correct. 14 and 15 are the existing requirements that deal with aviation. But I think I also wanted to take the opportunity to flag some additional requirements which we think are going to be needed on the aviation side of things as well.
Yeah, I think, sorry. Ms. Grange, we do have a fair bit to cover under 11 and 12, so how far we can take those points, given they were not in the agenda, I can't promise, but I think it'll help us enormously if you do cover off at least what it is that you require, and then we'll get an applicant's comments on that. But yes, so over to you. You don't need to repeat anything that was said at SIH 4. I do have those notes, so pick up from where we left off there.
Thank you, ma'am. I'm Samantha Grange from Evershed, Sutherland, speaking on behalf of BAE Systems Operations. I can also probably comment on behalf of BAE Systems Marine as well, although Mr. Nathan Fern is also available online if I don't cover what he was intending to say.
Okay.
But fundamentally, we just wanted to identify that in terms of the aviation conditions or requirements that are within the draft MIC at the moment, the DIO MOD is taking the lead in respect of requirement 14.
Okay.
That requirement, the detail of the wording is under discussion as between the applicant, MOD and DIO. In terms of requirement 15, again, DIO MOD has a role, a very significant role in the agreement of the wording of that requirement.
Yeah.
But so does my client, BAE Systems Operations.
Okay.
We are in disagreement at the moment as to the precise wording of that requirement.
I see.
And we are looking to engage further with the applicant in relation to the specific wording of that requirement, which concerns the primary surveillance radar at Wharton Aerodrome.
Yeah.
Our specific concern in that regard is that the applicant's wording at the moment departs quite significantly from similar requirements that have been agreed as part of the other made development consent orders for a number of the Irish Sea offshore wind farms, and that have been granted very recently. But as I say, we'll be looking to engage further with the applicant on the detail of that wording. And then the only other point I just wanted to flag was in relation to some additional requirements that we think are going to be needed.
Before we leave requirement 15, just very briefly, and you may pick this up in writing, but there is a particular point which relates to the exclusion of foundations, which is currently proposed. Now, the reason why that is relevant is because if we're providing that no part of any wind turbine generator may be erected, etc., if foundations may be erected in any case, then essentially the spatial commitment has been made. Now, if at that point it then becomes necessary to adjust in microsighting terms, for example, in order to deliver functionality on the PSR, you're kind of stuck because your foundations have gone in and you've spent a lot of money. So I had a distinct question about that I wanted to make sure is reflected back into the process. Doesn't have to be answered now, but does need to be reflected in the conversations between the applicant and yourselves.
Ms. Grange, did you want to highlight what your concerns were with 15 before you get on to the other requirements that you're after?
So I certainly can do. Samantha Grange for BAE Systems Operations Limited. In the first instance, the fundamental point is that the requirement is quite far removed from the wording that we have agreed previously with the other offshore wind farm operators, and essentially we would be looking for consistency. We don't have a detailed rationale from the applicant as to why that wording, which has been included in a number of recent made orders, is not acceptable. And I think in the first instance, we would be looking to understand the applicant's position in more detail so that we can respond to the specific concerns that the applicant may or may not have in relation to that adopted wording. We also want it to be sort of acknowledged from the outset that mitigation is required. So far as we're concerned, that is the agreed position as between the parties, and that impact, there is an impact which is going to require mitigation, and the purpose therefore of the requirement is to find the most appropriate mechanism in order to secure that mitigation. Whereas the starting point for the applicant...
So 15.1a in your submission is inappropriate?
Correct. In terms of 1b, our position would be that the wording of that particular limb, again, it's loose wording, it's vague, talking in terms of arrangements being put in place by the operator to ensure the implementation of the approved mitigation scheme. Again, the wording which has been included in the other MAID DCOs of late is much more specific in terms of the staged process that the applicant will go to in conjunction with the DIO, Ministry of Defence and my client, to be satisfied that not only has an approved or an appropriate mitigation scheme been identified and approved, but that also that solution has undergone in situ testing. It's been identified as satisfying certain performance criteria from a technical and an operational perspective, which my client would consider essential, and that the mitigation has actually been implemented by my client before the turbines effectively start to turn and the development becomes operational. That's the only circumstance in which we can be satisfied that there won't be an impact on the primary surveillance radar. And as I say, at the moment, the applicant's preferred wording, or the wording that they have put forward in requirement 15, would not secure by some way that certainty that the appropriate mitigation solution was in place and had been implemented.
Ms. Grange, because we were not covering some of these matters in this hearing, I'm ever so slightly underprepared on the questioning here. But take it if you'd like. So what I was going to ask is if we receive some of this in writing, and we will then request a summary response from the applicant here, and then perhaps get a response from the applicant. I'm also looking at the statement of common ground, and I don't see some of these concerns raised in the statement of common ground. So we would like for the draft MIC wording to be included in the statement of common ground and some of those matters.
It's worth reflecting back to SIH4 and the fact a number of these issues did sort of partially emerge and are reflected in what I'm conscious that nobody around this table has yet seen and will hopefully see by the end of tomorrow, is the action list for that. There are also a number of prospective written questions that you haven't seen because they have not yet been issued. I think probably the best way to reflect this would be to observe that these are matters that, in relation to that particular requirement, are going to be put in front of you through a combination of action and written questions. I think the remaining question then of interest, perhaps in summary terms here, is what are the matters that you wish to see secured by requirement that are currently absent? In other words, you foreshadowed that more than just requirement 15 is required. And that be very, very useful just to have a sort of potted sense of that so that we can at least think about the degree to which that is adequately reflected in the emerging question set, because it may not be.
Amy Sterling on behalf of the applicant. Can I just jump in on requirement 15 before we move on? I mean, just to flag, requirement 15 has been in the draft MIC since the point of application, with some recent amendments in terms of the additionality principle. At no point have we had comments from BA operations on the drafting. We have been seeking comments on the drafting from the DIO and the MOD. This is the first time we're hearing of any comments on the drafting, so I would encourage Ms Grange, certainly as far as I'm aware, so I would encourage Ms Grange to share her drafting concerns, or that we can properly consider them.
Ms Grange, I think that's a valid point, and I must admit that one of the reasons why something as fundamental of that is not in this agenda is because it's not before the examining body so far. But we've already identified that deadline 4 is ages away. And I'm really hoping that the Statement of Common Ground will pick this up. And as I am starting to say now, because we are in the second round of hearings, we have only one further round of hearings, and 2 rounds of written questions. We are wanting to see full justification and amended texts and so on before the examining body, because I'm very mindful that we may get to a point where we have to make a determination on what we decide to put in the recommended MIC. So we would like to see some of that. So what I've got so far from you is requirement 15, A and B. And you are also going to support that with justification in terms of precedent. So what I always ask for with respect to marine infrastructure consents, as I have done previously in DCO examinations, is that please give primacy to the justification of what you need based on what the specific cases supported by precedents rather than the other way around. So, it's not the precedents that leads the reasoning as far as I'm concerned when it comes to changes in the draft MIC. So why you need something for the Vannin application in this draft MIC first, supported by relevant precedents. So is that generally understood? You did say that there were further requirements that you actually wanted inserted. Have I understood that correctly?
That's correct, ma'am, yes.
Okay. So again, if I give you an opportunity to very quickly put that before us, but once again, because this is not an examination, not in hearing, I do want a certain discipline of not, letting the agenda get out of hand.
That's understood. Thank you, ma'am. Samantha Grange, BAE Systems Operations. The additional requirements are in respect of any impacts on the air traffic service side of things at both Warton Aerodrome and Walney. So they would be items such as any impact on the instrument flight procedures, the minimum sector altitude, so the IFPs and the MSAs. We also talked in SIH4 about impacts on radio comms and telemetry. Now, these are matters, particularly in respect of Warton, that are the subject of assessment, ongoing assessment by the applicant, and there is a question mark disagreement between the parties as to whether or not there is going to be an impact at Warton on the IFPs and the MSA. So as I say, that is an outstanding matter, but if impacts on the air traffic service provided at either Walney or Warton are identified and the parties are in agreement on those, then BAE Systems, both operations and marine, would be looking to have that mitigation secured by a requirement within the MIC. The only other point I think to note is in relation to the NATS St Anne's PSR, which again was the subject of discussion at SIH4, and it was noted there that some wording for an additional requirement to deal with the impact on that radar and the mitigation required to address it was the subject of discussion between the applicant and NATS. But I think it's accepted that because BAE Systems Operations Warton utilise the feed from that radar, that we will be involved in the discussions in relation to that requirement wording.
I think this is fairly extensive. If you want to respond very quickly, but I don't want to put you on the spot. I appreciate that.
Amy Sterling on behalf of the applicant, I'm happy to respond very briefly. So in relation to the instrument flight procedure, requirement need for one, not need for one, our position varies between BA Operations and BA Marine, so between Warton and Walney. So for BA Warton, as we discussed at specific issue hearing 4, our assessment is that there's no implication for the IFP because they sit outside the zone of influence of impact. That was already discussed at that hearing. Therefore, no requirement is necessary, and the applicant is continuing to discuss that. However, for BA Systems Marine and the instrument flight procedures at Walney, my client has been in discussions with BA Marine and is proposing a draft requirement for the IFP, and we are looking to secure something around deadline 4. And then finally, sorry, just in relation to the requirement that we're also including for deadline 4 for the protection of gnats at St Anne's and Lowther Hill, as again discussed at specific issue hearing 4, there is an all parties call scheduled for the 19th of May. So I'm sure Ms Grange's clients will be participating in that.
I'm sorry, Ms Grange, can you just confirm that that has all the additional requirements that you're talking about, Ms. Sterling has just covered them off.
The only other point, ma'am, Samantha Grange, BAE Systems Operations, was in relation to the radio comms and telemetry potential impact, but that is the subject of an ongoing assessment by the applicant, so we don't yet have the conclusion of that assessment as yet.
Fine, okay, and that was picked up at SIH4, as I recall, so that's a matter of ongoing discussion. Okay, so you seem less concerned about those matters, Ms. Sterling. It's the requirement 15 that you seem more concerned on.
Amy Sterling on behalf of the applicant, and we were aware of the other issues. We've never had any communications on requirement 15.
Okay, so so I think all these second matters, so keeping requirement 15 aside, all of those other matters are covered in actions under SIH4, if I'm not mistaken. So they are. And then so everything relating to requirement 15, I think there's two actions. One is hopefully everything is agreed in the SOCG and in the draft MIC that you put forward a deadline for. But if they are not, then Ms. Grange, what we're expecting from you is justification, wording and precedence to support your case by deadline 4.
Thank you, ma'am.
Okay. All right. Good. Back to... Is that everything for you, Ms. Grange?
That is, yes, thank you.
All right, thank you. Okay, so back to protective provisions. So what I'm hoping to achieve over here is some discussion between the applicant and offshore wind farm operators on the absence of protective provisions. I'm not going to cover bullet point 1 because your position on the need for protective provisions to protect the assets or the proposed assets or the consented assets of offshore wind farms you've made quite clear at SIH4. So we don't necessarily need an update on that. But I am very aware that at deadline 3, there were 2 offshore wind farm operators who've withdrawn their objections. So it seems to me like discussions are ongoing. With that in mind, it would be really helpful for you to just give us an update on where you are with the others and what are the chances of, you reaching an agreement outside of this process?
Amy Sterling on behalf of the applicant. Discussions are progressing well with Walney Extension, which is Walney 3 and Walney 4, in relation to a commercial agreement, in relation to financial compensation for energy production loss. The applicant is also discussing with the other, there is no commercial agreement proposed for any of the other operating or in development assets, but I feel like the other operating assets, the discussions are nevertheless progressing well as to whether or not they could withdraw their representation. I don't think there's much more I could say now, in all honesty, in this examination. In relation to the in-development assets, so Mona and Morecambe specifically, as I mentioned at specific issue hearing 4, I think ultimately there's a disagreement between the parties as to, whether what we've provided is sufficient, and they disagree. We think it is. I don't think that's going to be resolved.
So I think let's not talk about the wake effects that we discussed quite extensively at SIH4. I'm concerned more about the protection of assets, or making sure that those are not disturbed, and just perhaps it's actually good at this point to bring in some of the other parties if they'd like to make a representation on where you are and that justification, because we are coming up to deadline 4, and as you recall at SIH1 we said deadline 4 would be the opportunity that if matters are not resolved, that you put in draft wording for protective provisions at that point. So Mr. Gregg, I see you've got your hand up. If you could just, tell us where you are.
Thank you, ma'am. Michael Gregg, Daly Piper for the Walney and Wads IPs. I think the issue, I suppose, the remaining issue in terms of what you set out there probably is in relation to navigational impacts, where we still have a concern about potential navigational impacts in terms of ability to undertake necessary maintenance works in combination with the works to be undertaken by the applicant. We noted that the applicant included a new requirement 26 at the last deadline, which will include notification of vessel routes and timings, which is, I think, helpful and welcome. We're giving some consideration to that. Just to be clear, ma'am, my clients aren't necessarily wedded to the concept of having to be protective provisions as a mechanism. The concerns that they have could be capable of being addressed in various ways, whether it's protective provisions, requirements, or agreement. And I think from our perspective, at the moment, there is the potential to utilise the requirements that are already in
that's good.
the draft order as a way of addressing those concerns. So requirement 26 obviously gives a degree of notification of when vessel movements will occur. I suppose from our perspective, by that stage, there may already be works planned, and maybe the concern would potentially be about whether those are compatible with the timing of the works proposed by the applicant, and what we will come up at deadline 4 with proposals, but just by way of advance notification, what we were thinking about at the moment was potentially using the new requirement 26 in combination with requirement 6, which already has the implementation plan that includes notification of the notification that includes the timing of works. And what we had in mind was potentially having a requirement for consultation with affected parties on that, so that which could serve a twofold purpose. One, giving further potential advance notification of parties of when works are going to happen, which would then be solidified in the notification procedure in that new requirement 26. Plus, also, if there were considered to be any significant issues, then those could potentially be taken into account by the applicant, and also by the department in deciding the terms of the approved implementation plan. So that's the position for the moment, ma'am.
Amy Sterling on behalf of the applicant. The only thing I would suggest is, rather than sort of trading drafting and the examination, if Mr. Gregg is able to share his proposals with us in advance of the deadline, we would certainly welcome that, and we would consider if there's a change that we can make to a requirement that would satisfy him, or indeed, maybe the outline vessel management plan, we're happy to consider it. I would rather we did that collaboratively than just have to respond at deadline 5.
Mr. Gregg, you did say that was something that you were hoping to set up, that collaboration between yourself, applicant, and other parties. Who did you have in mind?
Michael Gregg, DLA Paper. Sorry, ma'am. I think I may have confused you somehow. That was not the intention. It was collaboration with the applicant on this.
It's just between yourselves and the applicant.
Correct. Again, quite happy to take up Ms. Sterling's suggestion there and propose these in advance of the next deadline. So I think that makes a lot of sense.
You said deadline 5. I'm sure you meant deadline 4. Okay, fine. So that is an action then. So you're going to share with the applicant your suggestions with regards to the outline vessel movement plan, requirement 6 and requirement 26. And then you're going to do all of this ahead of deadline 4, and there will be an update to either the draft MIC, the management plan, and the statement of common ground at deadline 4 then. Yes?
Amy Sterling on behalf of the applicant, yes.
Is that understood, Mr. Gregg?
Yes, and Michael Gregg on behalf of the Wolney and Watts IPs. Yes, that's understood, ma'am.
Okay, and
in that regard, I think it's probably worth us considering the scope of that action, because obviously Mr. Gregg is one offshore wind farm operator representative. There are others, and there were others engaged in SIH4. I think we should probably at least frame the action in a way that gives them the potential to engage in that process, should they wish, whilst not requiring them to, should they not wish. That would be my observation on that.
Amy Sterling on behalf of the applicant. Yes, the thought that we had actually in advance of this hearing was a sort of marine navigation engagement forum type requirement, which wouldn't necessarily be restricted to these parties. That's why I'd like to align with Mr. Gregg on what he's thinking and what we were already thinking. It wouldn't, in our view, necessarily need to be restricted to the parties that he's representing, but we'd like to discuss it with him. Shall we just, Mr. Gregg, you've got your hand up.
Yeah, so sorry, ma'am, it's Michael Gregg, DLA Piper, Wolney and Woods IPs. Again, that all sounds very sensible. It may be that it would be useful having a call between the parties, just to talk it generally. I'm again entirely open to suggestions from Ms Sterling as to how we best deal with that, whether it's best that we provide some drafting or whether we just have some discussions. I have no strong views on it.
Let's not do that at the cost of at least this collaboration progressing. But if you were to do a cross-party discussion, as Mr. Smith and you seem to have agreed would be worthwhile, then who would that involve?
Amy Sterling on behalf of the applicant. We weren't proposing a sort of round table with everyone. I think it's really difficult to get people together. I think what I was suggesting is what we did propose in the MIC wouldn't necessarily be restricted to benefit the parties that Mr. Gregg is representing. So we had intended to be drafting something a bit more broadly. So I just want to align with Mr. Gregg so that he doesn't necessarily at the same deadline say something that we're proposing another slightly similar but slightly different thing.
Okay, I think then that would be that that would be a really good point to get any other parties, other offshore wind farm operators, if they're online or present here, to state their case. I don't believe there are any other parties, but I just want to make sure that I'm crossing. No, okay. Okay. In that case, I think I am going to leave the other bullet point and, seek responses from other parties in writing, unless the applicant wishes to.
Starting on behalf of the applicant, no, we're content with how we've left things.
Okay. So... Okay, so I'm going to... Yeah, exactly. But the thing is that we... let's move on to agenda item 12. As I said when I was making my opening remarks and gave an overview of the agenda, that what our agenda did say is that for management plans, we were going to cover them. Well, we covered a lot of them during SIH 4, 5, and 6. And we gave you a bit of advance notice that under agenda item 12B, what we'd really like to cover is a bit of is to basically look at some control mapping across the draft MIC in relation to what typically gets controlled through a draft marine license. So I want to jump straight to that, if that's okay with the applicant. And what we're looking is to basically do control mapping activity by activity, just to make sure that in the absence of a draft marine license, and the principle of that is, I'm not saying accepted, but the principle of that is something that you've already put your case forward at SIH1, so I don't want to rehearse that. But given that there isn't a draft marine license, how can we map that all the controls have been covered in the draft MIC? What are the activities? What is authorized? What plans must be approved? Who approves them? And, whether any of the overlaps exist. So what we have been looking at as an examining body is a document that was produced for MONA, which is a marine license principles document. And we're basically looking at that as a bit of a almost like a framework. It's a good document which kind of maps that, and I'll hand over to Ms. Pownell to explain to you what we're trying to achieve. But we just want to see how that approvals matrix, in a way, is something that you can draw out for us, and it would be a helpful test for yourselves to see whether anything has been missed, and indeed for us. And the type of activities that we're hoping to cover are things like removal, UXO, disposal, ground investigation, dropped objects, etc., the sort of things that tend to get covered by Dream Marine License. But I'll hand over to Ms. Pownell, who's going to explain this better.
I think my colleague summarised it very well, actually, what we're trying to achieve. Excuse me. I thought I might just take a step back for the government departments, if that's all right, just to talk through, because I think the applicant understands what we're talking about. But just on the basis of the discussions we were having yesterday with the wildlife licence, I thought I'd take a step back and just talk through what the panel are thinking in terms of a demarine licence, just to provide the context. So the demarine licence is something that the English authorities use, the Marine Management Organisation uses, across all marine activities. It's not just for a DCO, but the DCO has it as a schedule attached to the DCO document. It does kind of conflict a little bit because you get plans that are in the DCO and plans that are in the licence, and it's cross-pollination, as it were, which causes some frustration. But the licence does provide a suitable envelope for all the marine activities and almost checklists and processes to ensure that the marine environment's thoroughly protected and nothing goes awry. So thinking within that context and looking at MEMA, MEMA disapplies, I think I've got the list here. So MEMA disapplies, can you hear me? The Water Pollution Act 1993, the Submarine Cables Act 2003, the Minerals Act 1986, the Petroleum Act 1986, the Wildlife Act, which we've been through in great depth, the Fisheries Act 2012, the Petroleum Act 1998, and the Ramsey Bay Bylaws 2011. So at the moment, when you have infrastructure in your territorial waters, for example, if I wanted to build a cofferdam in your territorial waters, you would turn to those acts and all the nooks and crannies within those acts to authorise that activity. I'm assuming that's a fair summary. Is that right? Question to DEFA.
Ken Milne, representing DEFA. Yeah, that's right.
Yeah, okay.
Numerous acts.
So I understand. So I think MEMA was the philosophy which possibly DCO could have warranted in terms of amalgamating the processes was the principle for amalgamating those processes. So I think what the panel are getting to is, has there been a thorough check that all the activities in those acts that have been disapplied are now covered in this MIC? Because if they're not, as we've been through with the Wildlife Act in great depth, there may be issues that are not covered that will fall through the cracks. Does that make sense?
Ken Milne, representing DEFA. I think you summarised it beautifully there. Yeah.
Is that right? So if I turn to the DOI, the DOI present. Mr. Garden. So Mr. Garden, I appreciate this is slightly off-piste, but are you able to state with confidence that the draft MIC and all the outline plans that support that, and I think the applicants created a very helpful summary plan schedule, a document within the submission, D1077, which pulls together all the documents. It might be worth putting it up, Mr. Randall, I'm so sorry. So I think, do you understand where I'm coming from, Mr. Garden? Are you comfortable that, we've lost Mr. Garden now because of the showing, but if you just scroll up the plan of the document just quickly. So this document's got in it, if we keep going, slow a bit more to the plans. So here, stop. So these are all the offshore and onshore documents the applicants prepared to manage this activity, and they all relate to specific requirements in the draft MIC. So if you go scroll up a bit more. So these are all the offshore documents, a lot of offshore documents, and most of these all of these documents will be covered by a demarine license. And the license will be very prescribed, with a lot of detail in it, when you start, when you stop, how you police it, all in one box. And that's what all your other individual acts do for their specific roles in our licensing process. So you can take it down, thank you very much. So I'll reiterate my question to Mr. Garden. Have you done that check? Are you comfortable that everything in all those acts that have been supplied and would be in a DEMA license equivalent in the UK is now covered, all the nooks, crannies and hooks in the marine license, the draft MIC and the supporting plans?
Yeah, Mr. Garden, on behalf of the Department for Infrastructure, I think it's a question you've rightly posed of a couple of the departments, given that they have different responsibilities here. I think in terms of the full cross-check, I think that exercise probably does need to be undertaken again to make sure that everything is there that needs to be there. And I think it follows on from the questions when we went through topic by topic yesterday in terms of ensuring that the outline management plans pick up anything that the kind of DEFRA in particular would expect to see covered in relation to those matters. In relation to the form of the documents and the schedule that you just attached and the various plans, etc., that are secured in the requirement schedule to the draft MIC, generally, I think we've used what would ordinarily go into a marine license to inform our analysis of what's there, what needs to be covered, and I think it's fair to say that the nature of the outline plans that are proposed and the structure of the conditions largely mirrors and reflects what you would see in a deemed marine license in English, Welsh, Scottish waters. But as for that absolute check that everything is picked up, I can't confirm that today, no.
No, that's absolutely fine. I think we're raising it so that it is picked up, because we now have time at the peak of the examination to just thoroughly go through, check everything's there, tick all the boxes. So can I ask then that, oh, sorry, I should turn to DEFRA as well. I'm so sorry. DEFRA, do you have a response?
Ken Milne, representing DEFRA. I agree we need to do that cross-check. It's for both departments to go through it.
So I think one action is for both departments to do a thorough check of the marine infrastructure consent and all the supporting documents that applicants helpfully pulled together in the document we showed up, D1077, to check that all the hooks are there in the outline plans, so that when the plans are firmed up, the contractor knows exactly what he asks for approval for, because having been on site and at the other end of this process, if there's no hook there, the contractor doesn't necessarily do it. DEFRA.
Ken Milne, representing DEFRA. Could I just make one point, please, Chair? Obviously, it's DOI that give the approvals for all these plans. Yes. Could we just ensure that anything that might have an environmental impact, that DEFRA is definitely consulted as well? Could we make sure
in the review? I thought you were going to do
in the actual plans themselves as well, if that's...
you've already asked for that, haven't you, for yourself to be an approved... Oh, no. At the moment you're consenting, you're consulted, not
we are consulted, that's right. Just to make sure we are consulted, including for any pre-construction works as well, so we're not missing off anything.
Okay. Yeah. I think you've made that application. I'm so sorry.
Yeah. Mr. Milne, I think that you've made that point, but what would be helpful is if you look at a document that which is called the sequencing of approvals of the outline plan. I don't have the EL reference number with me, but I will come up with...
It's an applicant document.
It's an applicant's document. They've submitted and updated all deadlines, and I would suggest that is the document for you to look at and to make sure that you are inserted absolutely at the right points. And I was literally going to raise that point, that it's not just about the hooks, but it's also about the triggers for approvals, to make sure that those triggers for approvals are indeed correct when it comes to some of these activities, and not just the triggers for approvals indeed, but for consultation as you've identified.
So we were going to ask, my colleague raised the MONA document. It's called J9, Marine License Principles Document. And so we were like to ask the applicant if they could go through that document and tell us where the similar activity is in the MIC and supporting documentation, and if you don't have it, why you don't have it, just so we can do a cross-check against a process that we're familiar with at DML. We're just trying to cover all all areas here to make sure the government departments are comfortable, that we're comfortable, and that you're comfortable, that everything's in there that needs to be in there.
Amy Sterling on behalf of the applicant, yes, happy to do that. And just to confirm, the offshore requirements were based on the deemed marine licence for the generating assets for Hornsey 4, so they were based on a marine licence precedent. We're happy to do this cross-check with Mona.
Thank you so much. You understand why we're going through this? Yeah, thank you.
Just with relation to that sequencing of approvals for the outline plans, the EL reference is D3-015. Okay. So I'm satisfied with agenda item 12. And the time is so the time is 20 minutes past 3. I'm quite happy to take an early coffee break now. Can I request let's take a slightly longer coffee break. Shall we do 20 minutes to 4? Yep. Okay. Thank you. Okay, the time is 3:40 p.m. and we are resuming session 4 of specific issue hearing 7. This session is on the policy framework before us, and as I said, I do intend to cover off all 3 agenda items here. Having said that, and as I said in my opening remarks, that the planning balance agenda item 13, it's likely we would touch upon it in agenda item 5, and we did. So a considerable amount of discussion has already emerged, and particularly in relation to the export-led nature of the project and the role of economic benefit within the planning balance, and the relationship of the broader strategic objectives and the more localized adverse effects. I'm not intending to repeat all of those questions here, but what would be helpful is to just consider A and B just as a bit of a summary. Is that what's become clear the applicant's position, as I've understood it, is effectively that economic benefit to the Isle of Man government is itself benefit to the people of the island, and because the government is democratically accountable and exercising its function on the benefit of the behalf of the island community. So you don't see as the benefit to the Isle of Man government as being strategic and removed from the people of Isle of Man. Okay. But what's become quite clear from public meeting 2 and through today's discussions is that I think parties are approaching planning balance from quite a different perspectives. While I've heard that logic in the applicant submission, we have also heard repeated concerns from local authorities, principal stakeholders, and other members of the public that the adverse effects are highly localized and physically experienced within the islands, and whereas some of the principal strategic and energy benefits are externalized to the UK market. So what I would welcome, and I'm not asking for this today, what I would welcome is submission from parties on how that tension should actually be approached within the planning balance under Section 36 of MEMA. And what I am keen to receive is those submissions from the applicant. From the government department, I would ideally like to hear this from Department of Infrastructure as the major landowner and in a way the client, but also from the Department of Enterprise, Treasury and Cabinet Office as the policy maker. So I'm going to put this down as an action for all 3 parties. At the same time, I think what would really help us get a full picture is to get a submission on this from local authorities. What I would encourage, although in that, is that we receive some submissions which represent a majority view, although it's not in my control. I'm not going to control that. But it would be really helpful to receive representative submissions on that. So local authorities, if you could provide your views on that point as well. So if we could put that as an action to 3 groups of parties, applicant being one, government departments being another, and then local authorities representing, the other principal stakeholders would be the 3rd group of people. So I've kind of ticked off agenda items A and B, and unless parties present in the room have anything further to add to that, I want to move on to agenda item 13C. Yeah, okay. So, and this agenda item 13C is also responding to various public consultation responses and various submissions at hearings and other deadlines. That to what extent were local authorities engaged in the policy context, in determining the policy context for this application. And I think it's fair to put this question to the applicant first, but I'm very keen to hear what government departments have to say on this.
Toby Yates on behalf of the applicant. So my instructions on this are that the councils weren't consulted specifically in relation to policy as part of the pre-application procedure. The pre-application consultation that was carried out is detailed in the consultation report, which is APP-174, and that sets out in full how the applicant has complied with all of the relevant legislation and guidance in relation to pre-application consultation.
In your opinion, should they have been?
Toby Yates on behalf of the applicant, no, because it's not considered necessary as part of that process, although obviously having said that and welcoming views as part of the examination process, we're seeing the submissions that are being made by various parties as part of the consultation that followed the consultation exercise carried out by the Council of Ministers. And obviously now that they're being raised into examination, the applicant's taking them into account and responding as necessary at this part of the process. So the answer that it wasn't necessary as part of the pre-application process, but of course the applicant's taken into account those comments that are being made at this part of the process.
Yeah, so with by updating your planning statement and so on. Okay. How about the government departments? Do you have any comment to make in terms of how you engage with local authorities on determining the policy context for this project?
Ken Milne representing DEFA. I think this is probably more a matter for DOI to respond in because they are the sponsoring department for the local authorities.
Yeah, Mr. Garden, on behalf of the Department for Infrastructure, I think local authorities have been consulted on the legislation historically and on obviously the application, as Mr. Yates has explained. I don't think there has been express consultation in relation to the policy context with local authorities as part of that legislative consultation process.
So what, Mr. Garden, is your response to those parties who are saying that we should have been consulted and our views should have been sought earlier than the application being accepted by the council?
Mr. Garden, on behalf of the Department of Infrastructure, I think obviously local authorities have been consulted through the pre-application process and I think are now raising those policy issues. I think that the applicant has summarised it effectively. What they can do now is take into account those comments, and obviously there's reference in MEMA to other policy statements which haven't come forward as yet. But I don't think there's any other process that could have allowed for consultation in the interim.
Did you say that local authorities were consulted during pre-application?
I believe they were by the applicant, albeit not specifically on policy. Is that how I'd understood Mr. Yates' answer?
Toby Yates on behalf of the applicant, that's correct.
Mr. Smith, Mr. Smith from Garth Commissioners, would you like to comment on that? What is your experience of the engagement during pre-application process?
Jamie Smith for Garth Commissioners. I think we feel that with our very limited resources as volunteers and a very small number of staff, that the weight of importance that the policy, that the hierarchy of policies have really wasn't put over to us, and possibly that's partly on us to not have understood that. But it felt, we feel, I would say, disappointed with our government departments, perhaps, who should have helped us in that regard and effectively left a vacuum that we've now tried to step up to, but then there's a slight feeling that our efforts are now possibly too little and too late, and residents do feel let down, rightly or wrongly.
And when you say helped out, do you mean in terms of providing you with resources to respond to some consultation, or what do you mean by that?
I think possibly just highlight, Jamie Smith for Garth Commissioners, I think possibly just highlighting where in the process we stood and at which point we probably need to be engaging with residents, so that, for example, I think it was July 2024, there was an email sent round. It was not dissimilar to other round-robin emails to local authorities, referring to some of the consultations that were in flight, and if you page down, about 4 pages down, you'd find the drop-in sessions, which were the very first public consultations. That was all that was. There was no visit that I'm aware of from a member of a department saying, look, you know, guys, you need to wake up to this. This is going to be important. And so it really was quite late on in the process that we feel that we were truly engaged. The engagement, yes, but whether it's sufficient, I would question.
Mr. Smith, that's really helpful. But we are where we are in the examination, and during the course of this examination, how do you feel you can meaningfully contribute? We've asked you for local authority effect statements, and GAF commissioners and Douglas City Council have submitted one, and obviously that is something that the examining body will determine what weight to give what's in those LAES, and whether that's relevant and important in our considerations. But just, you know, how do you feel you can meaningfully contribute, and in what areas? We feel we are probably sort of front and central, whilst other authorities may have an input, that the examination body and the applicant is looking to GAF commissioners to front this up. And some of the issues we actually regard as being national rather than just purely local to us. So I'm talking about the effects on tourism, the effects on government initiatives to increase the population, to encourage our students who tend to go to the UK to study to come back to their homeland, and government initiatives on things like mental health and well-being. And we feel we're fronting this up, and we're not the people who should be doing that. And that's partly why we feel let down. So we will do our best, and we will keep pushing the opinions that we're receiving from our residents, because that's our mandate, is not our own personal opinion, but as that. And so we'll keep pushing on that. But we do feel that we're fighting the fight for for the whole island nation in some ways. To sounds a little bit grandiose, shall we say? But that's how we feel in some ways. Thank you. And I think just to reiterate the point that the local authority effect statements is something that is an examination, both from yourselves and Douglas City Council. Any responses from the applicant?
Amy Stirling on behalf of the applicant. The only point that I really wish to make was just might be helpful, and one for the Department of Infrastructure and perhaps DEFA to consider, is in section 5 of our planning support statement. We set out from around the early 2010s a sort of long line of documents, some of which I believe were consulted on, which set out the government's policy intention to support offshore wind. So I guess the point I'd wish to make is when this application was submitted, it wasn't the first time people were aware that the government, or should have been aware, that the government was supportive of offshore wind. It might be helpful for the DOI and DEFA to review that document list and indicate which, if any, were consulted on, the scope of that consultation, etc., because that might be helpful.
Well, DEFA and DOI are both here. Your planning support statements have come in, revisions almost at every deadline, so it is there for them to comment on. I'm not going to put that in as a hearing action, but you're listening to comments here, and, you know, you can look at that. Okay. Ms. Newton.
Just as a resident of Garth, and what's been said before, I understand that the DOI, in drawing up the regulations for this, deliberately de-scoped local authorities out of being consulted on the scoping report. So if they'd been included in that if Garth commissioners had then had it on their agendas, then local people could have made much more input into this process a lot earlier. Garth is very much dependent economically on the tourist industry. From the MER, SMR, we had 124,000 passengers on the Snaefell Mountain Railway, 155,000 on the Manx Electric Railway last year. That is a huge number of people passing through Garth, particularly through Laxey. The tourist value of that, in terms of being able to see the coastline, money spent in the area, is huge, but it's been ruled out by government in terms of putting forward the regulations in the first place. So I think there's got to be a lot of emphasis given to the local economy, but it's because of national economic benefit. Everything else has been ruled out, and I think that is the problem that we're coming up with against trying to make our case now at a rather late stage.
So I think that some of that, in terms of the timing, while it's helpful for us to understand, there is limited scope within this examination for us to change or review that. But what we have opened the opportunity for local authorities to do is to provide a narrative in terms of, you know, how we consider some of these localized effects with respect to some of the national benefits that have been set out in policy terms.
Could I just add, I mean, to give you an example of the tourist industry further, the last week in May, first week in June is TT fortnight. Based on figures last year, we will have 39,400 people visiting the island, which is almost, it's about 40-45% increase on the island's population. 11,000 motorcyclists. That's the sort of input we get over a fortnight, and that is a huge economic spend again in our local area. So I think we've got to weigh those impacts in, and government do not seem to want to know.
Thank you, Ms. Newton. That's helpful, and as we've said before, that a lot of this is evidence before the examining body. Okay, I don't want to dwell. I think, as I said, that the agenda item 13C was very much about us getting a view, getting more understanding of some of the concerns that have come before us in terms of consultation, at least on policy context, from relevant local policies. I think we do get that picture now from both sides, from government departments, the applicant, as well as from local authorities. So I'm quite happy to move on from that point, which very neatly brings us to agenda item 14. And that's a policy compliance schedule. Now, we touched on this at SIH 5. There was an action issued to you, which was to produce what we're calling an accordance table. You referred to as an accordance table as well. Given that policy framework, that policy context, and indeed that policy hierarchy, there's more clarity before the examining body. I don't think we have a full picture yet, but there is more clarity. Given that that's coming to light, I think this policy compliance table is going to be really vital in this examination. And I think what would be really helpful is two things. I think it needs to have almost two tiers. One is an application-wide, taking it in the round in terms of that almost that set of exam questions that the NPS, for instance, puts for its examining authority. What are those exam questions that you're trying to answer before you do that planning policy, the planning balance exercise? So there's one which is an application wide, but then there's, I think, the policies which are relevant per chapter or per receiving environment becomes extremely important as well, and that might have a different level of granularity. So we saw in the landscape LVIA section that would, be quite key in terms of determining, for instance, if you were to take a step back and try and work up what you're doing without prejudice, the landscape enhancement scheme, a policy compliant, what are the relevant policies for landscape will really inform that in terms of what weight you give to some of those designations. And that will be very different to, say, marine mammals and so on. So I think we need it at those two levels. And I see a distinction between your planning statement and this policy compliance schedule. The planning statement I almost see as a little bit of a promotion document in a way, but the policy compliance schedule, I think it would be really helpful for the examining body if it is quite neutral and objective in terms of that assessment that you're making as an applicant. And we will then seek input from government departments in terms of whether they feel that that is accurate. Just one thing to say on that, and we have been asking for this right from the beginning. We asked for it in the Reg 31 letter that was issued before the Reg 32 letter as well, is that we do want to get an understanding of hierarchy, because as you can understand, one of the questions before us is what gets primacy over the other. So again, the applicant's view on how that hierarchy works, and I think SIH5 had a really, really interesting discussion on that. So let's hear from you, and then of course I see a really important role for government departments to play in shaping that, and for us to maybe come to I can't say, at least for the parties to come to an agreed view before the close of the examination, and for this to be before us. Okay. So this is an update required. I'm just looking around the table.
I guess if I can add one dimension to the Chair's observations there, and that is that we've already reflected to a degree on the distinction to be struck in English or Welsh practice terms under the Planning Act of 2008 between an approach where a decision is being taken within the framework of designated national policy statements under Section 104 of the Planning Act of 2008 and the different framework, the smaller framework provided by Section 105, and the way in which examining authorities there have investigated the broad raft of applicable policy and interrogated at considerable length the relativities and relationships between policies, the tierings, the hierarchies, what drives what and why, recognising that there isn't always agreement around the table. Now that's a process that is relatively rare in NZIPs in England or Wales because most of them proceed under designated national policy statements. But where it has happened, you can go back to the reports on examination and you can see the difference, often because the reports are thicker. But I just thought before we close that item out, it's worth reflecting on the fact that what's happening here is in fact a very similar kind of policy diagnostic exercise. And the reason why we're labouring it in the way that we are is because we consider it to be a similar diagnostic exercise to the Section 105 exercise. So if you're thinking about the how-to on this, hopefully that gives you a sense of assistance, and it will assist anybody. So, Manx government departments or local authorities, anybody wishing to see how others have done this in the past, look at the decisions that have preceded, the recommendation reports that have proceeded under Section 105 of the Planning Act of 2008.
Okay, thank you, Mr. Smith. Ms. Fernandez?
And I'm thinking again about the policy compliance schedule, and I think there are two things that would be helpful. One is the hierarchy, and two, whether there's any conflict between the policies and the compliance identified therein. And I know we did touch upon this on SIH5, but I think that's really, to us, sort of the nub is, to some extent, the hierarchy is one thing, but it's actually when we're getting the conflict between policies, where is your opinion sitting? What do you think about that? And then that will give us something to go back to governments on.
Amy Sterling on behalf of the applicant. Yep, thank you, Madam. You've actually preempted my comment, which is the applicant will use, best endeavours to provide its view on the hierarchy of policy and what happens in the event of conflict. Ultimately, we don't set the policy or manage the policy, so we will do our best for deadline 4, and then we will reflect on what the other government departments have said they will submit at deadline 4, which I think unfortunately probably does mean another update to the planning support statement to reflect what they've said, because it would be really helpful for us if the government could confirm what their view is, and if they're able to do that in advance of deadline 4, then of course we can directly to us in discussions we're having, we can seek to review that in the planning support statement and these separate accordance tables. Sorry, I'll breathe. And then finally, just to confirm your position on having a sort of one overarching and then one EIA topic specific was exactly how we were proposing to approach
Excellent.
it.
Ms. Sterling, just so that I'm absolutely clear, an update to the planning support statement throughout the examination is absolutely fine, but we see this accordance table as slightly distinct from it. Yes? Okay, so as long as we're clear on that.
Now, at risk again of over-embroidering, but I did recall that one of the side remarks earlier on in this hearing and in a previous hearing was in relation to the policy significance vis-à-vis the planning system and decisions under MEMA of the island plan as distinct from the strategic plan. So if somewhere along this journey we can touch on the island plan and tell us how we think that fits into, that would be very valuable.
Okay. Right. So unless DEFA or DOI have anything further to add about this agenda item 14, I was going to move on. No. Okay. Good. Moving on to agenda item 15, and I think we very, very briefly touched on this at SIH 5, but I do want to talk about, and of course we've had submissions on this, the emerging marine, I call it emerging, but I think it's quite far from emerging still, the marine spatial planning policy. And I'm just inviting a discussion with DEFA and the applicant on the status of this and, what the steps are, where you are, etc., etc.
Ken Milne, representing DEFA. As you rightly say, we have submitted a written response to this about where we are with it. I would just like to say, there is no actual requirement for a marine plan under MEMA or a need for one to be in place before an application can be made. And the DEFA Marine Spatial Plan is in its very early stages. We do have funding from Treasury, but there will be no significant, substantial policy perspective be available for the end of this examination period.
No draft policy, in other words.
No. So, and just, you've kind of almost preempted question 15B, is that there's no requirement in MEMA for there to be a marine plan, therefore the timing of the application being premature is is not even a question.
Ken Milne, representing DEFA, yeah, that would be our take on it. And it's just to be clear, this is the Marine Spatial Plan, so it's looking at the building on our Manx Marine Environment Assessment, which we previously did, which was the baseline environmental data of existing constraints within our marine environment. It was updating that, mapping it onto a zone, which could be used by DOI under MEMA if they wish to use it as part of their marine plan, but it's not a marine plan per se under MEMA.
Yeah.
Yeah.
It's the survey stage if we think back to old-fashioned plan making.
Yeah. That's correct.
I mean, I think in that respect, the observation that I would like to test with you, Mr. Milne, is that the sort of general approach historically around the relevance of emerging plans is that once you get to the point where you have a consultation draft that is published and ventilated, that it is capable of being taken into account, and then prospectively its weight increases over time depending on the degree to which it becomes a seriously entertained set of policies or proposals, and then finally is adopted. But because we are in survey stage and we haven't got as far as even a consultation draft of them, or even issues and options papers, as I understand it, even earlier than that, which are sometimes published, you're telling us that there won't be published equivalents of either an early draft or issues and options papers until after this examination is closed.
Ken Mill, represented EFA, that's correct. Our current timeline is it'll be well into 2027 before anything comes forward.
Okay. Good. I think that leaves... yes, I have a few A and Bs as well. So I think that makes agenda item 15C ever so slightly redundant. Mr. Garden, you've got your hand up. I was going to come to you, so apologies.
Oh, no, thank you, Mr. Garden, on behalf of the Department of Infrastructure. I just want to be clear, and I think we are, but just to be absolutely clear, that marine spatial plan is not the marine plan or the marine policy statement that's referred to under MEMA in relation to both the decision making and Section 51. It's a separate spatial plan that DEFRA is promoting.
Okay, that's really helpful to understand. And while that distinction was there, it is really helpful to have that distinction very clearly stated. Okay, so I think that closes all the substantive items on this agenda. I have a few matters that I do want to cover off, AOBs, but I believe Ms. Fernandez does too. So if I hand over to you first.
Yes, just a couple of quick things from SIH5. The first thing is, how long does it take to pull together another photo montage visualization? What's the sort of lead-in time for that?
Dr. Ciaran, on behalf of the applicant, it depends on what exactly that you're referring to. So if it is an amendment to an existing viewpoint photo montage, then that can be done quite easy. It's just getting new photography. If it's a new location or a new scenario or something, then that can be quite extensive. That may take up to a couple of months to get complete. So it's
going to be a new one,
a new viewpoint. Yeah. So the new viewpoint, then, if you give us locations for that, then we would need to get the photography. So it's the wireframe, so the model's already set up, so we'll just be getting the appropriate photography. So that could be done within a few weeks, just depending on the weather conditions and timing of the consultant to be able to go and take that photograph and then prepare the wireframes and the photo montage.
I just want to make sure we don't run out of time, so I'm sort of hesitant to give you half a job and then say I'd like something different. Also on SAH5, at a previous deadline, you provided a list of all the areas where we discussed landscape and visual impact assessment, sort of a helpful navigation document. And I did mean to ask if you would update that at each deadline as relevant if something has changed, as we've got new examination documents or so on. Just keep that tracker up to date if you would, please. Does that... There was a navigation document saying the SLVIA is in this part of the application, this part, and then, so at that point it was correct at that moment in time, but obviously we've had maybe 2 deadlines since then and more information coming in, so if you wouldn't mind just keeping that up to date at each relevant deadline, that would be helpful.
Amy Sterling, on behalf of the applicant, yeah, we'll review the relevant document and update it. Thanks.
Is that everything for you, Ms. Okay, so just a few other related...
There was a related item, but if we just consider it first. There was reference also made to that VR visualization tool that was used in the early stage consultation, and our understanding, I just wanted to check that it was correct, was that that was undertaken in relation to the 100 turbine scheme at 180 metres to zenith, so it is a different scheme essentially that was modelled in that to the current scheme. Can I just check that that was correct or not?
Yeah, Dr. Ciaran, on behalf of the applicant, that the previous scheme that it was the scheme at the point of scoping, so it was the full extent of the red line boundary that has since been reduced.
The full extent of the
100 turbines and 5 offshore platforms. The full extent of the AFL as per the agreement per lease, but then we've since reduced it down. So it is available. The headsets are there. We have them in the office. We've checked. It's all ready to go. So we can make that available for you, or we can update it to the existing application. That's what I mean.
I was just going to ask the simple question that maybe isn't simple, and that's the reason why I wanted to check it. Can it be with reasonable facility updated to the current scheme? Because if that's reasonably easily done, then I think if we were going to essay into using the VR, to not have the current scheme available, given that it isn't evidence, it's just impressionistic context, it would feel really probably not very useful to engage with just the original larger area scheme. So we were then going to test the proposition of how easily is it adjustable to model up the new scheme within the current RLB.
Dr. Carroll, on behalf of the applicant, I'm just speculating. I mean, I would imagine if the consultant has time and is free to do it, then the update shouldn't take too long. It took us probably about 3 months to get it done the first time because there was a lot of teething problems in setting up the model and getting the lighting correct and the layout right and the perception right and everything like that right. So now that it's been set up, the refinements I would imagine should be relatively quick, but I can confirm that and come back.
In timing terms, target, if we were going to ask for it, and we take on board the need to clarify that as quickly as we can, but the target would obviously be for around the July hearing window, because...
I would imagine that's going to be possible, yeah.
Thank you very much.
Amy Sterling on behalf of the applicant. They're just confirming that July should be fine, so nothing.
No, that is fine.
Yeah.
I did confirm.
Okay, thanks.
Okay, just a few points just about the just a few matters to cover off under AOB. One is the statement of commonality. Could you please have a look at the statement of commonality that was submitted for Lower Thames Crossing? And that is issues-based. It's not based on, you know, whether there is a statement of common ground, which just seems to be like an update on, you know, where you have statements of common ground. The statement of commonality for LTC and actually for a lot of NSIPs tends to be issue-based. And I appreciate that the issues that you're covering in statements of common ground is not common, which means that that list of that matrix is likely to be large, but we'd like to see a statement of commonality of that nature. Second point is that your statements of common ground, the RAG coding tends not to be complete. So there isn't always the green, amber, and red in there. And in order to do the statement of commonality of the kind that I'm asking for, you would definitely need to update and make sure that that's completed.
Amy Sterling on behalf of the applicant. Dr. Caroline suggested we might need to add in another colour to reflect that we're still under discussion rather than, you know, just not agreed or not material. I think we can review the colouring and ensure that they are updated. Another comment I would make is that sometimes the reason the colour has been removed is because when we've received comments back on the statement of common ground, the person we're discussing it with has removed the colouring because they do not wish to indicate it as a final position, which is why we've kind of ended up where we are. So
Why could that colouring not be amber during the course of the examination? At the end of the examination, everything can be red and green, but during the course of the examination, everything that's under discussion can just simply be amber.
Amy Sterling on behalf of the applicant. Amber, as I believe, without having my template in front of me, is not agreed but not material. This is why I think we need another colour to reflect under discussion.
Okay, so then your statement of commonality would need to reflect a 4-colour rag something. Yeah? Okay.
Rag plus blue.
And then one thing that we'd asked for in our very first Regulation 31 letter, and this goes to both the applicant and parties that it is entering into statements of common ground, is that we wanted all our statements of common ground to be prefaced with what we were calling, to identify principal areas of disagreement. Where there were principal areas of disagreement. So I'm just thinking about some of the larger statements of common ground. It is really helpful. We do not want this as a separate document. We just want this as an appendix or a preface to the statement of common ground, and it would really help us, at least at this stage in the examination, where to focus our minds. It is just worth highlighting for people who are listening to this conversation that statements of common ground in themselves don't form evidence. They are simply an examination tool. So, these are just methods for us to examination tools. And then just a final point, we've noticed that in some of your comments to submission, submissions that have come at previous deadlines, you have just said that we're not responding to this because, or rather you've said we're only responding to submissions where we've not responded before. That's your choice. If you decide to do that, that is your choice. And of course, if we seek specific responses, we'll ask for it. But I think what will help the examining body, and I think it'll help your case, is if you're not responding to something, to highlight where you feel the response is placed. So respond to everything, but if you are not going to repeat something that you've already said, please signpost where that response is.
Dr. Kieran, on behalf of the applicant, I just have a query in relation to the statement of commonality. It just lists all the stakeholders down the left-hand side and then receptor topics across the right. So it seems quite crude in what it's trying to capture, because it just has a traffic light system. So it kind of pulls everything that falls under, say, geology and geomorphology into one colour coding, and it doesn't really... Is that what you want? Because that seems quite difficult quite subjective in terms of what it can represent. Because within each receptor topic there might be a variety of issues, and then trying to summarise them into one colour coding seems quite simple. An oversimplification, that's all.
What's your suggestion?
To not do a statement of commonality. And then what we spoke previously with DAFA about was our experience of working with Natural England. Say on Horsey 4, and Natural England now just don't partake in the statement of common ground process at all. They just use an issues log. So to basically take on your recommendations and what are the key principal issues that remain, we could get that into the statement of common ground, and then we could have an issues log with DEFA and some of the key stakeholders that sets out all of the issues. So it gives you a little bit more flavour of what the detail is, but then what the key areas that are, or the principal issues actually that are outstanding in the statement of common ground. So that's what we had proposed, because the statement of commonality just seems quite crude.
The statement of commonality is quite crude, but it gives a fairly good idea of how conversations are progressing at a glance, especially where the colour coding from the statement of common ground is consistent with the colour coding in the statement of commonality. The statement of commonality, basically what I'm trying to say is the statement of commonality that you've submitted right now is of no use to us. And so if you make it issues based, so for instance, what I would be looking at, for instance, would be things under the draft MIC, and it would really help me understand where matters are still disagreed. So it is fairly crude, but that in combination with this principal areas of disagreement at the at the top of all statements of common ground, I think will really help even parties, I feel, to really focus discussions. So
think of it as not telling the full story, but actually being essentially the strategic junction box at the top of the story. And I think, I mean, reference has been made to Lower Thames Crossing Statement of Commonality process, and I mean, I was panel lead for that for my sins, and it was a very, very large process indeed. And one of the things that was very useful in that process, and I'm conscious that this is a much smaller process, but nevertheless, to have tools that sit at the top that essentially direct your attention and prioritization into the more detailed tools that sit beneath. So yeah, look, I found that, my panel found that to be, despite its crudity apparently, a very, very useful starting point. And I mean, that is essentially what we're asking for.
Dr. Keir, on behalf of the applicant, happy to prepare one, and then maybe just what we can do is strip out of the statement of common ground issues that are not agreed, not material, and ongoing points of discussion, so that it just reflects what are the key principal issues.
Strip out of the statements of common ground. No, don't do that. Oh, I see. I wouldn't quite go to that extent yet. Let's get the statements of common ground with the addition of the principal areas of disagreement at deadline 4. And should we want a revision to that, we will think about it. But so it's a statement of commonality which is issues based rather than just progress based. So just issues based. Principal areas of disagreement as a preface to each statement of common ground, and that change to colour coding. Is that it's these 3 areas that we want updated for deadline 4. Yeah. Okay. Good. I think that covers everything. I'm going to just look around the table. Excellent. So the time now is actually, I am going to very quickly look around the room. I'm getting ahead of myself. Any further points? Okay. Oh, you do?
I've been debating this, and I am going to ask you for this viewpoint now. It's up the Heritage Coast, if you would, looking southwest, St. Bees, Heritage Coast, England. So we have quite a few on that western coastline, but from St. Bees Head looking southwest, please.
Do you want us to submit something to you for clarification, or do you want us to just go and assume we know where that point is on St. Bees Head?
Shall I clarify exactly where in the hearing action so that you know?
Oh, okay.
Yeah, but I just wanted to, on balance, it's helpful for you to know that
okay,
is what we're after.
Okay.
Thank you. No, it'll take them probably a bit longer than D4. How long do you... I mean, it's not pressingly urgent for D4, so realistically, I don't want to be giving you a deadline that actually you just can't meet. So D5, D6, where are you on that?
Dr. Keir, on behalf of the applicant, 2 things I'll do is I'll take away the action on the virtual reality headset and just come back and confirm that once I speak to the consultant, and then the other, I'll go and speak to our consultant on SLVI, and I'll come back with it in the post-hearing submission to confirm the dates for delivery for both of them. We'll do them as soon as we can.
So let's target D5, subject to you saying that that's not possible, if that's all right.
And Dr. Caroline, given that we are here, is there anything further that you would wish us to clarify in the action note that you don't already know about that VR matter? Or
Dr. Keir, on behalf of the applicant, I think it would be useful to have a discussion around the night time, around the lighting, because we really struggled. So, and this just the consequence of basically the VR capabilities, the model setup, and what it's capable of reproducing from a lighting perspective. So I'm happy to share this with you. You can see the daytime views look realistic. they're really immersive, and you're at Laxey and you're there, you feel you're there and you can see it, and it gives a real world representation as you look up and down the beach and up to the sky. At night time, it's not as realistic of what the real world situation is. It really isn't. I live down in Brighton, so I see these things regularly. I'm familiar with the West Coast. I know what they're like, so it's the experience is, it's quite different at night time. So it's just what we do with that nighttime part.
Noted, and equivalently subject to the caveat that we don't believe that the nighttime representation is necessarily as good as it ought to be, and subject also to the experiential dimension of this that I think all of us at various different times have on multiple occasions viewed offshore wind farms at night in operation with lighting systems fully operational. With both those caveats in place, I think at the moment it would probably still be useful to see the nighttime, but we will, take it subject to the caveats that are placed over it and in the light of real world experience.
Yeah, Dr. Keogh, on behalf of the applicant, I suppose what I was trying to get to in terms of conversation was we can seek to amend the model to make it a more realistic version of what we believe to be the reality, or we can just update the model to be exactly the same as what we showed at the events, so therefore it represents what others have seen, if that makes sense, but
yes.
It's just a reduced array. But my preference would be to try to get the night time to be reflective of the real world situation.
Excellent.
Slightly.
Yeah, that would be very helpful.
If you can.
If we can.
Yeah, let's
okay.
Look at it.
Good. Thank you very much. And then once again, thank you to everyone, those who are here, but also extended to those who are not, for contributing. It's very helpful. Actions will be issued as soon as possible, and so we're not going to summarize them here. We've been through them in quite a lot of detail, so I'm not expecting any clarifications are needed. The time now is 4:32 p.m. and I'm closing specific issue hearing 7. Thank you very much.